Yes.
Plus my prayer for listing motion, Your Lordship, 2 minutes.
Motion. What is the offense? Bail. Bail or what?
Bill, AB.
What is
Motion.
the offenses?
Assaulted, Your Lordship.
Huh?
Assault, Your Lordship.
Physical assault.
Assault will mainly be grave, maybe hard. What is the punishment?
25 and 307, Your Lordship.
307. Okay.
May I please? In my case also, my lord, this is 326 and 307. And petitioner.
I have a similar prayer, Lordship.
But just you be careful whether it is 7 and above.
Yes, sir.
That much.
7. I beg to mention item number 14, Lordship, for admission. For seeking adjournment, Lordship, today my senior is having some personal difficulties.
Okay.
Kindly indicate a fixed date, Lordship, if
Fixed date will be difficult.
Short.
Allah prayer of the learned counsel for the petitioner. Matter stands adjourned and be listed after weeks. Yes.
another prayer for listing of a motion.
Uh-huh.
Listing of a motion. Lordship.
Motion.
3 years.
Bail.
Bail.
BA.
Lordship.
Just verify whether it is. Just help us.
No.
Should not be listed which are
Okay.
not before.
Lordship, I beg to mention the supplementary item number 35, Your Lordship. I have taken the concept of the other side, Your Lordship. I am the newly engaged counsel, Your Lordship.
You are for?
I'm for a petitioner, Your Lordship.
Petitioner. Learned counsel on the prayer of the learned counsel for the petitioner. Matter stands adjourned.
If my lord may fix a date, Your Lordship.
What is the issue?
The criminal revision petition is, I am not aware of it because I have received the brief only last night, Your Lordship. I'm yet to go
You
to
are
the.
not even aware what is in the brief. Prayer of a.
I received it only last night, Your Lordship. That's the thing. I'm
So
yet
you
to
are not even aware except in the brief
It's-
that what is the matter about, what is under challenge.
It's under the.
Prayer stands rejected. Next case.
It's an NIA claim. It's an NIA, Lordship.
On the prayer of the. Have you taken consent from the other? On the prayer of the learned counsel for the petitioner. Matter stands adjourned. Petitioner and be listed after 10 days. Yes, next case.
Pay, please, Your Worship. I
Yes.
beg to mention item number 22.
20.
22, Lordship, CD has been received, but it requires updation, Lordship.
Updation.
And they are already on interim, Lordship.
Okay, the learned additional public prosecutor submits that those CDs received, however, they will require an updated case diary. Accordingly, press for an adjournment. Prayer is allowed. Please this matter.
21st of May.
21st of May 2024. Interim order passed earlier shall continue till then.
Highly obliged, Lordship. Item 1.
Plan appears for the petitioner account next week. Yes. Where is the affair?
Yes, 7.
Huh?
Yes, 7.
Yes.
Yes, 7.
When can you have the case date?
Lordship, this is from Ganesh Gut case. 13/5, Lordship.
13/5.
If it is possible on 9, Your Lordship.
Okay, 9th, let us see. Already from 15/3, 9th. All right.
Please, Your Lordship. Lordship, application after 4, Your Lordship. Page number 14, Your Lordship, FIR.
His mother-in-law.
Mother-in-law and sister, Your Lordship.
From which place?
From
Khetri, Your
Khetri,
Lordship.
Lordship.
Kindly see the forwarding report, Your Lordship.
10/5, Lordship.
Forwarding report, Your Lordship, 18 page number. Second paragraph from the button, Your Lordship. During the course of investigation from the statement of the witness, it is found that the husband of the deceased always suspect on her about the illicit relationship with the other person and he used to torture her regularly. The witness strongly suspect that the husband of the victim, Sri Sanjay Uran, killed his wife and it is plain murder. Your Lordship, at the time of the incident, the petitioners were not present in their house, Your Lordship. Only 47 days behind the bar, they are, Lordship. They have been arrested only because they are mother-in-law and sister, mother and sister of the husband of the deceased, your lordship. And,
How can you have it at the early date you?
Your
you
lordship, 9 or
Ninth,
must oblige your lordship.
ninth. I think they maybe because she was in her mother's place. She was taken by this. We'll see.
Only for half an hour, this incident happened. That time, the mother and sister, they were in the field, your lordship.
they were present also, that is in the forwarding. Objection.
There's no any,
Okay, on ninth we'll see.
my lord.
Yes,
My appeal is your lordship.
yes.
This is a 438 bail application, my lord.
Hmm.
FIR is page 11, my lord,
Yes.
or 11. Petitioner is the accused number 2. Named accused, my lord.
This is item number 4.
4, my lord. Operating party is page 12.
Yes.
12, my lord.
You are not named in the FIR or name.
And name accused number 2, my lord.
Accused number?
If lordship kindly comes to page 17, lordship, earlier rejection orders, there lordship, the petitioner's name appeared as accused number 2, and the materials are at page 18, lordship. 4th paragraph, lordship, will kindly see the alleged victim, page 18. Grievous injuries there, lordship.
Okay, we'll come.
Affidavit, my lord, my lord, is a my lord issue relating to the my lord the selling of 2 tickets against 1 seat, my lord. The petitioner was
I
not
understand, but can a conductor be beaten for this city?
allowed granted my lord interim bail, my lord, regarding 4 persons, my lord, and similarly situated person, my lord.
In
It
this
is-
case,
Yes, your lord, in this affair, my lord. Petitioner is a part of the gathering, but he was not involved in the move, my
in
lord.
this case, bail granted.
Specifically named, lordship.
My lord,
Huh?
kindly see, my lord.
He's-
They
Who
all
are
are
they?
named,
They are named.
all are named tickets, my lord. All are named tickets, my lord.
When this matter is fixed,
My lord, this is my lord 13, my lord. 16, my lord, 16.5. My lord, another a BA petition fixed on my lord 8. I think we are 8. My lord, interim may be granted and may be fixed on 8, my lord. A B number, my lord, 122 of 16, a BA number, my lord. 122 of 6.
considering the fact that co-accused name in the affair has already been protected by this court in AB 917/2020 by a coordinate bench. In AB 917/2024, the petitioner also is protected.
8 to 16 percent, 8%.
ভালোই ইন্টারিমতো দিতে কন্ডিশন বিলাক দিব একেদিন একেবাৰে দিয়া নাই উইদিন 2 weeks বুলি লিখি থৈ দিছে
BA 8 আছে মানে।
আগতে আছিলে আপোনালোকে নতুনকে আৰম্ভ কৰিছে এইটো গতিকে মই চহী কৰি আছো নহয় ইহঁতে কালি স্মিতাহঁতে দি আছে মই চহী কৰি আছো অকল আপুনি দিয়া নাই কালিও মই চহী কৰিছো স্মিতাহঁতে দিছে চ' এইটো সেইখিনি কণ্ডিশ্যনছ খিনি দি দিব দেট ইজ ইম্পৰ্টেণ্ট ইণ্টাৰিম
Lordship. 16, lordship, same date,
8
8.
Highly obliged, your lordship.
in the meantime you 8 হলে বেশি নাই তো in the meantime you get your statement
Highly obliged, your lordship.
this is item
5 PM. 5 PM. May I please, Judge? 438 petition, page 10 is the affair. 3 petitioners before all are brothers, your lordship. Page 10 is the affair. The previous day, informants on physically assaulted the petitioner's mother in absence of the petitioners.
we'll call for a case there
Lordship.
Though this is written as 326, your lordship, but she was not admitted. Okay. Yeah, short date.
From Dhubli, lordship, 10th.
10th
Please. May I please, your lordship? Lordship, the 438 bail application charged under section 394 and 419 Your Lordship. FIR is page 9 Your Lordship.
CD,
CD Lordship.
when?
Lordship, let it be on 14 Lordship.
14th.
Short date Your Lordship.
Ask him.
Lordship, because of AB only Lordship. 10th.
10th.
Obliged.
Item 7.
Your Lordship, 430 application of subsidiary matter Lordships. FIR is at page 17 Lordships.
Is
17 Lordships. There's Barnacular Lordships. May I read the FIR Lordships? For 6 months, this FIR lost Lordships of the alleged offense. And that too Lordships after filing my FIR Lordship, complaint Lordships.
uh-huh.
This FIR lost after 6 months of the alleged insurance Lordships. Yeah.
Mhm.
And that too Lordships after filing my complaint, this FIR lost Lordships.
Their complaint is at page 19 Lordship.
Yes, Lordships.
What kind of complaint is this?
Yes, Lordship. Actually,
This is your
I'll have a look the well, 28, page 28 Lordships. That is the Barnacular Lordships.
defamation Lordship, section 500.
500 or IPC Lordships.
Now, what to be done today?
But NBW has been issued law against me Lordship. On the first date Lordship, the learned magistrate issued NBW
What,
against me. M. Hawk.
Mr. M. Hawk, Learned Counsel for the petition. This is an application filed under section 438 of the Code of Criminal Procedure 1973 for grant of pre-arrest bail to the petitioner. Full stop. The petitioner is an seated accused in GR case number 1242/2023. 2023. Peruse the affair as well as the complaint case lodged by the petitioner,
Informant Lordships.
by the informant. So,
Petitioner Lordship, yes.
petitioner,
Lordship.
petitioner.
Petitioner Lordships.
It's a call for the scan copies of the case diary and the record case diary of Sipajar PS case number 272/2023 and the case record of PRC case number 133/2024 from the Court of Learned Judicial Magistrate First Class Dorong Mongoloi. Full stop. Till the next date, no coercive action. NBWA issued against the petitioner shall remain suspended.
Obliged.
List the matter on.
10 copy Lordship.
Give a date. Save. Imagine. No. After 3 weeks. 24th of May.
And develop.
FIR is page 15.
Yes.
15. We are not, I am not in this case, my lord. And the person, further, he already arrested. No,
Who are you?
I am working as a nurse in the Kolkata Civil Hospital.
Why you are apprehending?
Because they, in the FIR, they mentioned, the abortion has been done at Kolkata nursing home. That is why police searching me. And the person, main accused person, he was arrested.
Considering the fact that petitioner is not named as an accused interim. When?
20.
20. Appear before.
I love you.
This revision is directed against the conviction.
Appellate, both concurrent.
Yes.
Heard Mr. Deka, Learned Counsel for the petitioner. The present revision petition is filed. assailing judgment and order dated 30/12/2021 passed by the learned subdivisional judicial magistrate Tinsukia in CR case number 14 of 2018 and the 13 passed by
the subdivisional judicial
Magistrate Tinsukia in CR case number 14 of 2018 and the judgment and order dated 5/3/2024 passed by the learned additional session judge number 2 Tinsukia in criminal appeal number 8 within bracket 1/2022, whereby the judgment and order dated 30/12/2021 was upheld. Issue notice. Issue notice. Returnable 4 weeks, steps within 5 days, steps by both ways. Returnable give after 4 weeks, till the returnable date, the impugned judgments dated so and so, so and so. No, not impugned judgment. The petitioner shall remain on previous bail.
Apply.
10.
Make legal lordship.
Yes,
Lordship, this is a criminal petition directed against order dated. Might we find
Pardon?
out?
Mr. S. Nawaz, learned counsel for the petitioner. The present application is filed against an order dated 19/2/2024 passed in PRC case number 74 of 2023, whereby whereby Jimma of certain documents / materials were claimed by the present petitioner were rejected. First of issue notice to the respondent number 2 and PP accepts so and so after 4 weeks. Huh? Date, give a date. 5/6.
Develop. Yes, legal lordship.
Yes.
Well, this is a 482 petition, my lord, for
Hmm.
quashing of an FIR, the charge sheet and the subsequent proceedings, my
Hmm.
lord. If your lordship will kindly see page number 15, my lord, annexure 1.
Hmm.
My lord, the petitioner entered into an agreement for sale with the original owner of a land,
Hmm.
this Mathura Mohan Rai. If your lordship will kindly see
Who
the
is the
next,
petitioner? Ruby.
Ruby, my lord, Ruby.
Okay.
If your lordship will kindly see the next page, my lord, it says that,
And
my
who
lord,
is the informant? Mathura.
Mathura, not Mathura,
Okay.
it's subsequent purchaser, my lord.
Okay.
My lord, page number 16, my lord, it was
So this was an agreement with Mathura.
Mathura, the
Then,
original owner.
huh?
So, original owner of that land, my lord,
Okay.
by the petitioner.
Hmm.
So as per the agreement, my lord, the registered sale deed was to be executed within a period of 6 months, my lord. And it
By
was
whom? Mathura.
Mathura,
In
in
favor of,
favor of the petition.
in favor of Ruby.
Ruby.
Where is that?
My lord, clause number 5, page number 16.
Clause number 5,
Five.
page number?
16, my lord.
Yes.
That the first party seller shall execute the registered sale deed in favor of the second party purchaser within 6 months from this date.
Hmm.
If the first party fails to do the same within the stipulated period as aforesaid, the total advance amount will be returned by the first party to the second party.
Okay.
Now, my lord, as per the next clause, my lord,
Hmm.
it said that, my lord, if within that period of 6 months, my lord, the second party, that is the petitioner, wanted to sell the land in favor of a third party, my lord, then the first party, that is the original owner,
Hmm.
will be bound to execute the registered sale deed in favor of the third party.
Hmm.
That clause was already there in the first agreement, my lord.
Okay.
Now, my lord, we'll come to page number
2.
18.
80.
Annexure two.
Yes.
Now, what happened after 1 month, my lord? Ruby Hazarika, that is the petitioner, she entered into an agreement for sale for selling that land in favor of the informant of this case, my lord. That is at page number 18. Now, if your lordship will kindly see page number 19, in the very first paragraph, my lord, the facts of that the earlier agreement was executed was already mentioned in the first line, whereas a deed of agreement was executed on 3/3/2021 between Mathura Mohan Rai.
Yes. Then,
What happened, my lord? This original owner of the land,
Hmm.
he neither executed any registered sale deed in favor of the petitioner or the informant, that is the third party. So, my lord, this informant, she lodged an FIR,
Hmm.
that is at page number 24 against the present petitioner.
Hmm.
The main allegation is at para number 2, but thereafter,
space.
24, my lord, the FIR. That is the FIR, my lord. The allegation is in second para, my lord. But thereafter, few days later, I want to know that the plot is not belongs to her, and all the documents she showed me was fake after that, I said her to return the agreement money immediately, but till date, she will
What?
not return back.
Now tell us, why the investigation should not proceed? That will give you a clean sheet.
The charge sheet has already been submitted. Now, the allegation was twofold.
Where is the charge sheet?
Charge sheet, my lord. Page number 32. The police did not file charge sheet under section 468.
Hmm.
So police did not find any material regarding
Now
forgery.
charge sheet fine under what?
Only 420. Regarding 420, my lord, the allegation was that plot does not belong to me. That is an admitted fact. In the second agreement, which was executed in favor of the informant, it was
Right.
already
We'll call for the scan copies of the case diary.
Notice also.
Huh?
Notice.
Notice.
but any interim.
No. No, not for the timing, we'll issue a notice on interim.
Madam,
Ah.
next date is on 4th perhaps, madam. So any liberty or accommodation, madam, for that date, madam. itself. 1 day.
You file an application, say it, we'll see it. What is the date for on 4th?
For appearance.
Appearance, you can very well seek an adjournment. Is there no scope for any discharge 227 application before the trial court?
You will have to first appear there, then go for discharge.
Appear, go, were you in anticipatory bail?
Yes.
Then
That's actually, madam, she has.
what, is it a fact that because you do not want to appear, you will not appear? Use the scope under 227. File a discharge application.
in
Let the magistrate apply its mind. We'll take thereafter. Why should we exercise all the powers of magistrate? Tell us.
Apparently,
No,
my lord.
we understand, but apparently after charge sheet or apparently FIR will not do. We'll have to see the same exercise 220 or more or less 227, 228 power we'll have to exercise here. Because somebody is not liking to go to trial court
at
and
this
you
stage,
are
my lord,
burdening with the high court is 482.
at
Why
this
should you entertain this
prima
application
facie-
at all?
when prima facie, my lord, there.
We understand
Yes.
prima facie. Is there any, no, there is no scope for agitating this grievance before the trial
Yes,
court?
but that will come only after she appears.
So where is the
Madam,
question you have you not
my
taken bail?
My instruction is that, my lord, she is. My lord, she has
See,
no-
because your instruction is that a lady will not go to, not face a trial, criminal trial.
She is in such a position that she cannot even furnish security, my lord. So that is the problem, my lord.
That cannot be a ground. You are aware, well aware. Can that be a ground to entertain a 482 petition? That's why it's overburdened with the 482 application. And actual petitions, those who are convicted, those who are in jail are not being heard. Notice.
Highly obliged.
Scan copy also.
We'll call for the scan copies of the case diary of Swencho and PRC case. Give a date. 7th.
May I please, Lordship?
Yes.
Lord, for 38 application, my lord,
Hmm.
FIR is at page 13, my lord, translated copy.
This is item number?
12.
Where is the FIR?
But already Lordship has passed granted interim to co-accused and fixed the method on 21/5.
Okay.
At page 20.
Interim
Fixing the case on 21/5. Lordship.
21.5, my lord.
21/5 interim. File over.
AB number 1052, my lord.
Huh?
AB number 1054.
You have annexed it?
Yes.
Yes.
Annexure 2.
Interim granted, my lord.
Yes.
High level.
15.
May I please tell us? FIR page 13, my lord. And I have been in custody since 1 year, 11 months, my lord.
This
1
is,
year, 11 months, 26 days. I have been arrested on 16/5/2022.
what is the allegation?
Allegation, my lord, recovery of 200 grams of yaba tablets from 2 persons. I am one of them, my lord.
What is your ground?
Round, my lord, kindly see page 35.
Huh?
Earlier, there was an order, my lord. I have
Yes.
approached earlier on 8/11/2023. The court directed to complete the trial within 6 months. Page 36.
Now, what is the present status? How many witnesses are there?
14 witnesses.
How many examine?
Three, my lord.
Eight examine.
Three.
Three examined.
Three examine.
Three exam.
Let us see what is just then. Out of 11,
Out of 11, my lord. 14.
14.
who are these witnesses?
These are, one is the official witness, my lord. Another two.
Who Caesar witnesses are there?
Yes, Caesar witnesses are yet to examine, my lord. Two Caesar witnesses are yet to examine. my lord.
And what is the, who was examined? Who is PW1?
PW1, my lord. Yes, PW1 is also Caesar witness, my lord.
I think I have rejected this bill earlier.
No, my lord. The co-accused bail application, Habibur Rahman Baruya, your lordship was also directed to complete it within 6 months. That bail order is there, my lord. That I have, my lord.
Because we recall, many things I recall.
This is there, my lord. This is the order.
So that is a
Yeah.
vital.
Yeah.
Moment I reading the PW1, I recall, I might have dealt this matter 6 months back.
Yes.
Yes, yes, 6 months.
Co-accused.
Maybe more.
Yes.
We do not know whose bill. Reading the second,
Yes.
third line of the PW, I could recall that I'm dealt with this matter. So everybody be careful.
Okay.
Registry need not report us that whether filed or whether I have taken.
My prayer is that, my lord, let the other two Caesar witness be examined, my lord, at least, my lord. And there is, my lord, regarding the delay part, my, there is no delay as such, my lord.
2 years, my lord, about to complete on 7 and 15.
Because the trial is going on. And I have seen some
Still
orders.
have specific finding. Why have you withdrawn this order? We have recorded PW1. The independent Caesar witness has already been examined, who has deposed that the contraband has been recovered from the two accused petitioners. In the meantime, two witnesses have already been examined out of total 14 numbers of witnesses.
Yes.
In view of the aforesaid, in the considered opinion of this court, the petitioner has failed to satisfy that there are reasonable grounds for believing that accused is not guilty of offense charged alleged.
Yes.
My lord,
What is the new things
Dear
that
my lord, that 6 months stipulated period was granted by the earlier order on 8/8/11, my lord, page 35. Page 35. 6 months stipulated period, my
Now,
lord.
my lord,
That was about to
some
complete.
decisions has come, my lord, from the apex
So-
court that framing the time frame, my lord.
6 months, my lord, 2 years and recovery, my lord, only 200 grams here, 200 grams, my lord. And that was also, my lord, if I go through the FIR, that was not specific that whether it is recovered from.
in
here.
this case only on the ground of delay is difficult? How many
Yes.
days? What is the total period of conviction? If you are convicted,
10 years.
then
10
That-
extend to 20.
And almost, my lord, 2 years are about to complete, my lord.
wait for 5 years.
My lord, can we see that page 35 order, my lord? That court stipulated 6 months, my lord, which is about to complete, my lord. So consider that aspect, my lord.
About to complete.
Complete 8/11, my lord. On 8/5, my lord, it will complete. My lord. On 7/5, it will complete. My lord. Today is 2/5, my lord.
This court. Considered, this is an application under Swens. This court. Yes, PP, when can you have this examined? What was the last date?
The last date is in the February, my lord, from the LCR.
Where is the PW3?
Three is in
PW
the,
three.
first in the loose seat, my lord, in the
PW3 I have there, my lord, this PW3 and Amir Hussain, my lord, who is the police constable? Amir Hussain,
PW,
3, my lord, the official witness of spelling.
who PW3 is examined?
Examine.
Where is PW3?
3, my lord, in the LCR part, my lord, first 2
That-
pages, my lord.
That I have also, my lord.
In the LCR
Give
is
us,
also
give
there,
us.
my lord. It is not in the buns, my lord. It is extra, my lord. Java under কত আসলে? 36, no?
How much was the recovery?
200 tons.
200 grams of what?
Yaba tablets. This is in the FIR, my lord.
What is recovered is 10 packets containing 200 yaba tablets. In total, 2000 yaba
1000
tablets.
tablets.
2000 is 200 gram, my lord, in quantity, my lord. It is recorded in the FIR, my lord.
20 grams.
Each small packet contains 200 tablets.
Per tablet is 10 mg, my lord.
Dismissal right now or adjournment for after 2 weeks?
Adjournment, my lord.
Adjournment.
My lord, till then, my lord, after 2 PW examination of 2 PWs, my lord.
See, possession is established. Is not it? By 2 witnesses.
Yes.
Now only thing will remain is the other technicalities. On the prayer of the learned counsel for the petitioner, matter stands adjourned and be listed after 2 weeks.
16, my lord, I'm sorry, very not 16, my lord.
What are the offenses, allegation?
So let the offense is page 11.
Huh?
399, my lord.
Offense here is the 399. FIR is page 11, my lord. The petitioners, they came to Guwahati and on the way, my lord, the police, my lord, give signal and they stop the vehicle. And during charge, my lord, 4 numbers of machete and 2 pieces of plastic rope was recovered from their vehicle. And they have admitted, my lord. And these are the home use items, my lord.
Huh?
Not dangerous weapon, my lord.
Otherwise, my lord, in the, my lord, providing page 14,
Hmm.
they are involving in any other such cases, my lord, ground number 1, such type of cases, and ground number 3, my lord, other 3 cases, Mukalma PS, 3 cases are pending. So,
When can you have it?
my lord, twice we have given signal, my lord, signal but not received, my lord, one last chance may be given, my lord.
Okay, the
Uh,
petitioner was arrested. When? The
Well,
petitioners
Petitioners, 31-3, my lord.
On 8, my lord.
31-3-2020. What is the period mandatory 90 days?
60 days.
31-3 then
So this is 32 days.
33 days. to-
33 days.
Yes.
On 8, my lord.
Arrested on
31-3.
31-3-2023. Though case diary was called for on earlier 2 occasions. However, the case diary has not yet been received. The learned additional public prosecutor prays that he may be granted a last chance to produce the case diary. Prayer is allowed. Full stop. List this matter on
8.
8. Full stop. If no case diary produced
Eight,
on
my
the
lord, I will go to
Oh.
village for custody.
9.
So
Nine.
before 7, my lord, if possible.
Before 7, 6 today.
6, my lord.
same again election. This
Mm,
area
nine-
will also be under election.
9. It's Monday, Monday.
If possible, 5 is very short.
No. আজি 2.
9th.
9, my lord.
9.
And if on the said date no case there is produced, this court may proceed with the materials available on record.
I am blessed.
May proceed to decide this matter on the basis of material available on record. Yes,
Charge sheet submitted, my lord.
search sheet submitted. Search sheet submitted. BA.
Oblique 24 dated 31/3/24. Interim. No. Oh, BA.
Approach the track. With- Yes.
May I have lordship? Lordship, FIR page 12, lordship.
Hmm.
I went to the 39 days, lordship, behind the bar, lordship.
First was the FIR first.
FIR page 12, lordship.
Huh?
FIR page 12, lordship. Agent with the FIR behind the bar, 39 days, lordship. Delegation committing docility, lordship.
Well, case there is there.
My lord.
Lordship, nothing recovered from the person of the accused person, lordship. Only on suspicion that he is
Materials are
the driver,
recovered.
lordship.
My lord, yes, my lord, Dokaiti was done, my
Ah.
lord, from that vehicle, they took the vehicle to a different place.
Hmm.
And this petition is a truck driver, different truck. This truck was being that place and all the concerned were
Shifted.
shifted
To his truck.
to his truck.
Okay.
So he stated that at about night, stated that for a good numbers of yes. At night about 1 AM, he went for a person, and a huge amount of money has been given to him for a good. Otherwise,
And what about the others?
others, involvement are
They are
there.
involved.
Others are there. He was-
Considering the material so far collected against the present petitioner.
Yes.
Also, for the present petitioner. Who was the driver of the other vehicle
Others,
where the robbed materials
Uh,
were shifted,
shifted from the
were shifted from the original,
Informant truck to-
were shifted, comma, and also considering the period of detention, this
39
court is of the view that no further custodial detention of the present petitioner may be necessary. To the jurisdiction of
Lordship. 39 days agent to the lordship.
to the satisfaction of
to the service.
CDM Kamrup, lordship.
CCF Kamrup,
Amin Gaur, lordship.
Amingdao, CCF Kamrup, 25,000.
Alright.
10,000 going to driver.
31st evening.
So, CDM. May I please, your lordship?
Yes.
My lord, this is 439 application.
Mm.
The petitioner is behind the bar since like 35 days, my lord.
But CD not received, my lord. I was seeking time. My lord.
My lord, the fact is that, my lord, in this, the matter was earlier listed,
No,
my
no.
lord, and your lordship was pleased to fix the
Original case is not
listed on
available.
8/5, my lord.
No,
But
my lord,
subsequent to the,
CD, my lord, it was CD was called by the session just Kamrup on 26/4. I have stated that CD has not been returned, my lord. Because of that, my lord, could not be provided the case.
and that, my lord,
one development was there, my lord, that one of the co-accused, my lord, who preferred a bail, my lord, he was also arrested in this case on the same date, my lord.
Mm.
And he preferred a bail petition, my lord, before the learned Session Judge Amingaon, my lord. And he was enlarged on bail, my lord, by order dated 26/4/2024, my lord.
Where is that?
Order is, I could not collect that, my lord, at the time of filing, my lord. Subsequently, I collected the order, my lord. And therefore, my lord, I made a mention for updating my case, my lord. And your lordship,
Okay, yes,
No,
sir.
CD is fixed on 8 5 years.
Okay, okay.
And
35 days, my lord. on the date that-
then also I was stated that Malat CD is in that court Malat.
Yes, sir. That report was there on that matter also. That co-accused was released after 30 days of detention.
For considering the period,
Yeah.
okay. Hard Swensu. The case diary is not available. However, it is submitted by the learned counsel for the petitioner that a co-accused who was also arrested has already been granted by the learned Session Judge Kamrup Amingaon, considering the period of detention. Full stop. The petitioner and the said accused were arrested on the same
Same
date.
date.
Full stop. The petitioner has been in custody since
Last 35 days.
last 35 days. Considering the nature of allegation and stage of investigation, nature of allegation, considering the period of detention, the present application stands allowed. Conditions
CM Kamrup Amingaon.
20,000 Kamrup
Amingaon.
Amingaon.
Obliged, my lord.
Not be.
In this case, I am
Yes.
in interim lordship.
Huh?
I am in interim lordship and I appear before the.
Any tapping case.
Appeared. So, hey, Jitu, normal order. Order dated, earlier order dated
23/12/23 lordship.
20,
2/12/2023.
22/12/2023. Dispose of.
20.
20 lordship petitioner is on interim and CD has not been received.
When
22
22 interim to continue.
21.
Your lordship.
Yes.
Well, today is the 4th occasion, my lord, case diary was called, my lord. And in this case, my lord, the petitioner initially arrested in another case in PS case 370, 323, wherein they have that after this affair lost. In that case, allegation that petitioner tried to escape from their custody and they after they gunshot in my leg, my lord. Thereafter they lost this affair, my lord. Accordingly, the earlier affair lost against me, there's absolute bail granted me by the trial court below, which I have enacted.
Now you want AB in which case?
Now, my lord, 674 before your this honorable court, my lord.
Your
And
lordship-
373 already I have been granted bail by the trial.
Where
court.
is the affair?
Yes, my lord, page 12, annex
Yes.
1.
One. And where is the earlier affair? Where you have been, you were arrested?
My lord, that order here, my lord, page 15, annex 3, my lord.
No, what was the allegation in that affair?
It is reflected in the order itself, my lord.
Where is that order?
Page 15, my lord. I was granted interim bail after arresting.
What is this PS case number 673?
This is, in this case, I've been suspected that I failed to submit,
It is not necessary. Where is that FIR?
Lord, FIR, that FIR, this honorable court, I've requested to also call that FIR also, my lord, and that order, my lord, absolute well granted, this order is with me, my lord.
So one case is Barmish Supari.
My lord.
Now, what is about the
second
other case?
Second case, in this case, while they arrested me, then they have said that from their custody, I tried to escape from the custody, then they shot gunshot to me. Then
That is what?
that is instant affair, my lord. Thereafter, they lost this second affair against me, my lord.
No, this is third affair.
Second affair, my lord.
Second,
One is 673, first, present is 674, my lord.
Barmish Supari is
It's 673.
673.
And
Then
gunshot.
you were supposed to be taken to the hospital.
Then
Then you
second
Right.
affair lost.
try to
Escape.
escape. Then there was a gunfire. Then second affair. Second affair also you are arrested.
Second, already I'm on interim, my lord. This honorable granted, all in hospital, I am on interim, my lord. That case, my lord. Thereafter, I paid the affair loss against me, my lord. I filed a 430th application before the trial court below. That is rejected, my lord. Then I approached before this court.
You were in police custody.
No, my lord.
Then how can you?
I'm on
private?
interim, my lord.
Huh?
I'm on interim, my lord.
No, understand.
Yes, my lord.
Interim grant. You were in custody. You were taken to somewhere. Then there was a gunfire.
No, my lord. Kindly, my lord, let me clarify, my lord.
That's why the affairs are necessary.
Uh,
Earlier, there was a case of Barmish Supari. You were arrested.
yes.
Okay. That order is at 13/12/2023.
And forwarding report also submitted in the
You were released.
released, my lord.
Now, how this cases came that you were had a vomiting and tendency, you were pace,
Yes, please.
that's annexer 1.
My lord, that incident, they have said on 9/12, incident on 9/12/23, they arrested me. On 10/12, I tried to escape. But on 13/12, honorable court in the earlier case,
So therefore, this incident happened where you were in custody. 9/12 on your bail were granted on 13/12.
13/12,
This incident happened on 9/12,
10/12,
10/12. So you were in custody.
that time custody.
That is what I am asking time and again. Otherwise, how can you flee away from the police?
That is, I'm in custody, my lord. That time.
So you were in custody.
Yes, my lord.
According to them, you fled away. In the meantime, you have been granted bail in the other case on 13/12.
Yes.
Now 13/12, is there anything they have submitted before the court while granting you bail that he even tried to flee away?
My lord, this is the final bail order, my lord, passed by the under trial court.
Then your interim is rejected.
My interim rejected.
Why are you silent as regards his fleeing away on 13/12?
Lordship, that is why Lordship case
Huh?
that will be required, Lordship.
That is why he should be interim protected. Where are you now?
I'm outside, my lord.
You are in hospital.
No, my lord. I see at my home now, my lord.
When can you have the case diary?
From Polayan Lordship Kasar. 10,
That created whole confusion. I was correct, you were wrong. That's why I'm asking, you were in custody. You say, no, I has already been released on bail.
And yes, my lord, lordship correct, my lord.
You are not aware of your facts. That has
10,
created so much of time. 4 minutes to 5 minutes have been taken in a bail application.
10/9, my lord, I was in custody, my lord.
You are in custody. That's why that is the allegation.
Yes.
And your bail was granted
On 13.
on 13/12, meaning
ma'am.
thereby you were custody till 13/12. Yes. When?
10 Lordship.
10. The case diary was though case there was called by this court under its order dated 27 to 2024, same is not produced on 11/3/2024, on 8/4/2024, and today also, full stop. If no such case there is produced, on the next date, this court will consider the interim prayer made by the petitioner, in as much as this court may also direct personal appearance of the concerned officer in such.
23.
23 lordship, CD has not been received. Nine.
When to list, that is earlier?
10.
10. CD is there?
No lordship.
When?
Let it be on lordship 13.
13th interim to continue.
24.
Wait, please, the lot.
Yes.
438 application.
CD is there?
CD not received lordship.
CD not received, interim to continue,
21.
list when?
21 lordship.
21. What is this IA?
I was for correction, madam, it was done.
Okay.
Oblige, madam.
Received lordship.
Lordship. This is the FL lordship. There is a. scope
What
of-
is, who, you are a named accused?
Yes, lordship.
What is
Lordship,
your name? Nadumia
Yes.
and
And petition number 3, lordship.
Sorry, Mia.
Sorry,
Nadu and Sharif.
father and son lordship. And they lordship petition number 1.
Just
of-
a minute, just give me
Yes,
to
yes,
me.
yes.
Nadu and
Sorry, Mia.
Sharif me. Yes.
Yeah, lordship, the injury report is here.
Hmm.
It's grievous injury, lordship. The victim, he was hit in the right parietal compound calvarial fracture with underlying so and so. The injury is quite serious, lordship. And lordship,
And what are the witnesses are there?
the witnesses are there, and lordship, the in this seizure list also, lordship, one iron dowel and one fukuri has been recovered.
Hmm.
And the blood sample of the victim has also been taken, lordship, to match with the
Okay.
found in the dagger, lordship. Implications are there, lordship.
Okay. Heard. The learned counsel for petition, case diary, decision application under so and so, case diary is produced, full stop. The eyewitnesses testimony suggests involvement of the petitioner in the commission of the offense, full stop. The injury report reflects grievous
Grievous
injury.
injury caused by dangerous weapon.
It caused by grievous injury, and also reflects that such injuries were caused by dangerous weapons. Full stop. Considering the matter in entirety and stage of the investigation, considering the incriminating materials collected by the IU against the present petitioners, which are available in the case diary, and including the injury report, this court is of the view that the petitioners are not entitled for privilege for grant of pre-arrest bail. Accordingly, bail applications, anticipatory bail application stands dismissed.
Orders item number 26.
Bail is over. Yes, sir.
Your lordship, the appellant was convicted,
My lord, kindly taken up after some time, I will just go through the incident.
For admission item 13.
Please, my lord, matter may be passed over for a time being, my lord. My senior is on legs in another court.
Yes, sir. What is the info, update?
My lord, the
As per my information received from my lord, the learned counsel conducting in the Titavar, my lord, that the one execution case is my lord, instituted by the my
No,
lord.
that is,
respondent.
we want the,
Yes, my lord, that
we want the
that-
instruction, where are you paying?
area amount, my lord, that amount will be paid, my lord, in the executing court, my lord, as per my instruction, my lord.
My lord,
In-
no payment has been made till date, lordship.
Yes, my lord.
Despite there was no stay as to the maintenance, lordship. And
That-
recently we have filed an execution because of, with delay, my lord, notice was issued, lordship. My lord,
Mm.
till date they have not paid any payment, my lord.
What is the case?
My
My lord,
lord,
it is not numbered, my lord,
Huh?
execution, because
No,
of
no, forget about that.
present,
Ah.
that lordship will find the improved order at starts at page 30, my lord.
Hmm.
Relevant person lordship will find page 44. And the
What is your ground of challenge? Tell us that in nutshell.
my lord, my lord, first ground is my lord, the learned court below my lord has awarded a compensation of rupees 20,000, my lord, under sections 125 proceeding, my lord.
Hmm.
That, my lord, under section 125, my lord, there is no provisions for awarding a compensation, my lord.
Hmm.
That is, my lord, regarding the compensation part, my lord.
Hmm.
And my lord, secondly, my lord, though my lord, I failed to cross-examine the witnesses as used by the my lord respondents in the my lord court below,
Hmm.
and I also failed to my lord examine myself and other witnesses, my lord. But my lord, regarding my lord, the income of the husband, my lord, that has not at all considered, my lord. Earlier, my lord, I have my lord own business, my lord, but that was closed in the year 2018, my lord. I have made specific allotment in my WS, my lord. So awarded amount, maintenance amount of rupees 4,000, my lord, is my lord too high, my lord, considering my income. I am presently, my lord, serving in a farm, my lord, at Dimapur. That area part, my lord, I will pay, my lord. Because there is no stay, my lord, and that is, I will have to pay, my lord. And I have calculated, my lord, till the month of April, my lord, it amounts to 2,08,000, my lord. 52 months.
Why should we entertain this petition? Because of your conduct?
My lord, as per my instructions, it thought that, my lord, the stay has been granted, my lord. That's why, my lord, I could not pay, my lord. And presently, my lord, I am the petitioner, my lord, as per my instruction, my lord, is out of Assam due to, my lord, treatment of his father. My lord, next date of the, my lord, that execution case is fixed on 27/5 of this month, my lord.
রেকর্ড হয়েছে you have not laid evidence
But may I say that compensation part, my lordship, may interfere in view of the provisions of the 125, my lord.
that
My-
that will set aside
Regarding
we
the
are not interfering
maintenance part.
4,000 lordship, not much. Lordship.
not much and there is no evidence you have taken certain stand you have not even laid evidence
Yes, that's true, my lord.
okay hard Mr. Sharma learned counsel for the petitioner and Mr.
It's Rahman lordship.
H. Rahman learned counsel for the petitioner. The present revision petition Mr. Das for the state response. By the present petition filed under section 401 read with section 397 CRPC. This present revision petition is filed assailing and judgment and order dated 24/12/2019 passed by the learned subdivisional judicial magistrate within bracket M at Titabar, Jorhat in Mess case number 35 of 2018 under section 125 CRPC, by which the petitioner was ordered to pay a maintenance to the respondent number 2 at the rupees 4,000 per month. In addition, full stop, an amount of compensation at the rupees of 20,000 was also directed to be paid for the torture, alleged torture meted out to the respondent number 2 wife by the husband. Full stop. Full stop. Mr. Sharma, learned counsel for the petitioner, submits that the impugned order has been passed without considering the stand of the petitioner, inasmuch as without considering the fact that though the petitioner had a business earlier in the name of Messrs. Balaji Enterprise, however, said business was closed down in the year 2018, and therefore he was not having much income to maintain to pay the maintenance amount. Mr. Sharma further contends that the learned magistrate was not within its competence and jurisdiction to award a compensation amount for alleged torture, inasmuch as such determination of torture cannot be made in the proceeding under section 125, and there is and no power is vested upon a magistrate in exercise of his power under section 125 to award a compensation amount. Full stop. Compensation amount. Full stop. Therefore, the impugn orders are liable to be set aside and quashed. Per contra, Mr. Rahman, learned counsel submits that the learned magistrate, after examination of evidence laid by the petitioner and consideration of material available on record, has judiciously concluded and determined the issues framed therein, and therefore this court, under in exercise of its power and in exercise of its judicial power, should not interfere with such findings of fact not being perverse or not being legally sustainable. Full stop. However, Mr. Ahmed Rahman submits that will record it 20,000. That is a law, no way out. Submits that submits that the magistrate, okay, why should you blame? Okay, submits that though there is no specific power is given under section 125 to award compensation. However, the magistrate will not be powerless powerless to pass such an order in the interest of justice. Full stop. This court has given heard the learned counsel for the parties. Also peruse the LCR. Full stop. From the LCR, it is seen that the petitioner specifically pleaded and claimed that she was mated with she was not maintained by she and her daughter.
Only C only.
She was not maintained by her husband, and she could not maintain herself. For such, for the aforesaid case, the accused, sorry, petitioner, respondent number 2, respondent number 2 had laid as many as 4 witnesses in support of her contention. Full stop. The respondent, you have not even cross-examined.
No cross-examination.
The respondent, though file and written statement, did not neither cross-examine the witnesses nor he had laid any evidence in the proceeding. Thus, the testimonies of the witnesses who deposed in support of the respondent number 2 wife remain unrebutted. Full stop. Unrebutted. And on the basis of the unrebutted evidence, the learned magistrate has concluded that the petitioner is entitled for maintenance. Full stop. This court has gone through the deposition of the witnesses as well as the application and filed under section 125 CRPC by the respondent number 2 wife. Full stop. From the aforesaid, it is seen that she has duly established her claim through her witnesses, and there is no perversity in making the conclusion the same relates to the entitlement of the petitioner for maintenance as well as quantum. That being the position, this court, in exercise of its power in exercise of its revisional power, is not inclined to interfere with such decision. Now, coming to the provision of section 125. Section 125. Thus, I do not think compensation.
Yes.
Only the
CRPC
provides for compensation under section 357
uh,
only to the in respect of victims and when a sentence is
Ah,
imposed.
ah.
This is not a
Because
sentence. my lord.
it is not sentence, full stop. Section 125. Section 125 CRPC empowers a magistrate upon proof of neglect or refusal to order payment of compensation to among others to a wife who is unable to maintain herself. It further empowers to it further empowers a magistrate to pass an order to order a father of a minor female child to make such allowance until she attains her majority. If the magistrate is satisfied that husband of such minor female child, if married, is not possessed of sufficient means. However, section any of the section 125 prescribes or empowers the magistrate to award compensation. What is to be determined is that the wife is unable to maintain herself and that the husband is having sufficient means, neglects or refuses to maintain its wife. And if the aforesaid two facts are established, the magistrate can award monthly allowances for maintenance of the wife at such monthly rate as the magistrate think fits. Full stop. Full stop. There is, and therefore, in the considered opinion of the court, the magistrate could not have awarded the compensation amount that to determining it at rupees 20,000. Full stop. Accordingly, this court is of the view that such order awarding compensation to the tune of rupees 2,000 is not sustainable. 20,000 is not sustainable in law. And accordingly, same is interfered with. Full stop. Interfered with. Accordingly, the present petition stands closed with the aforesaid. Accordingly, following direction is passed. The impugn order, the impugn decision so far relating to award of compensation, award of monthly maintenance passed in favor of the respondent number 2 wife at the rate of rupees 4,000 per month is upheld. 2. The award of compensation of rupees 20,000 is interfered with. With the aforesaid, the
My lord, arrear may be paid within a specified period. Lordship,
Well, that
long-
I will pay, my
Well,
lord.
that
That
may
I
be-
have instruction.
As they have.
that
made
is
that
a
lordship.
482 difficult.
Yes,
You
yes.
file an execution here. We know that this is a sufferings.
We stipulate.
From 2018, my lord.
18
Yes,
is. they have not
18
paid
months.
lordship.
This court
time
has
frame
also noted that though this court has not stayed the award of compensation
Then it's-
and award of maintenance the respondent husband has not paid such amount till the date of order, since the date of order till now. In the view of the matter, should we pass a direction 482?
Time frame may be given.
Okay, at this stage, Mr. Sharma submits that the respondent, petitioner is now in Chennai in connection with Hyderabad in connection with for his father's treatment, and he will clear the area due within a period of
2,08,000.
2 lakhs. Tell us, we are giving you time.
2 months.
My lord, I have calculated it's, my lord, divided into 8 installment, 2,08,000, it
Yeah.
comes to 26,000
Ah.
plus 4,000.
Ah.
Monthly it comes to 30,000.
Okay.
That will be, my lord, right?
No, what you give us your proposal. Since we are sitting in Panchayat, let us do our job properly. Yes.
8 installment, my lord, area amount.
Okay. Now submits that the petitioner will clear the arrears amount within in 10 equal installments.
Obligement.
10 equivalent installments. However, he will continue to pay the current maintenance amount. Full stop.
Obligement.
LCR scan copies original. The LCR be returned back.
Obligement.
Yes. What is this?
Against maintenance, my lord, the honorable, my lord, granted maintenance 6,500 to the illegitimate child
Huh?
of the petitioner, my lord.
So
The- It is not bearable for the petitioner, but he is the worker who serving in a biscuit factory. my lord.
that cannot be a ground to do whatever you like. That cannot be a ground for interference.
As per direction of the honorable court, my lord, we have filed a rescission liability, my lord, before this.
Huh?
As per direction of this honorable court, my lord, we have also filed our affidavit of accession liability. That should be considered. Then, my lord, our judgment 31/2019, my lord, is 47.
Go to Supreme Court. So you have preferred before the sessions court.
Okay.
That is also dismissed.
Okay.
Huh?
Yes.
Heard. Mr.
Game over.
Swenso, learned counsel for the petitioner, and also Mr. Islam, learned counsel for the petitioner.
Respondent number 2, my lord.
Respondent number
State
2
of-
and Mr. Das for respondent number 1. The present application under section 482 CRPC, read with article 2 CRPC, is preferred for quashing and setting aside impugned judgment and order dated 30/1/2019, passed by the learned session judge Darang Mongoldoi. No. Judgment and order of the learned session judge Darang Mongoldoi in
CR case number.
CR case number 17 within bracket D-2 of 2018, whereby the judgment and order dated 8/5/2000, 18/5/2018, passed by the learned Chief Judicial Magistrate First Class Darang in MR case number 48 of /2015, awarding
6,500.
awarding monthly maintenance of rupees 6,500 per month was upheld. Was upheld. Full stop. The respondent was granted such award of such payment of maintenance was directed in favor of the respondent number? No.
No,
She is a respondent.
number two.
Huh?
Daughter
Uh,
of respondent number two.
In the name of daughter of respondent number 2, a minor, and a illegitimate child of the petitioners. Full stop. What is your argument? The only ground urged by the learned counsel for the petitioner assailing the aforesaid 2 order is that the petitioner is a daily wage earner.
wage earner.
What do you do?
Biscuit factory, my lord. I'm working as a labor.
He's working in a private company, and he is not in a position to pay such awarded amount. Full stop. Per contra, Mr. Islam, learned counsel submits that this court, in exercise of its power of revisional power, should not entertain such a petition where facts are determined concurrently by both the learned courts below. Full stop. This court has perused the material available on record and the LCR. Huh? No LCR.
Actually, not called for.
Not called for. Okay. Peruse the material available on record, including the 2 judgments. Full stop. So and so dismissed. We'll pass that.
There is
Huh?
area maintenance, my lord. Same maybe.
To pay the areas of maintenance.
3,38,000, my lord.
When,
As
how will
on,
you pay?
as on, my lord, 29 to 2000.
Only
Let us not pass any order right now. You go to the executing court. The file there.
This
Hmm.
matter,
Hmm.
I recently received the complete paper book.
Hmm.
It's almost 800 pages long. I have started preparing it. I need some time in order to. I'm in 29. I've been appointed as amicus in 29.
20.
9. After the last order, Your Lordship, I was supplied the complete paper book.
Okay. This court, under its order dated 11/1/2024, directed to provide the paper book. How much? Paper books. That is volume 1 to the learned amicus. Full stop. The learned amicus, Mr. K.P. Pathak, submits that he has received the record, but it is too voluminous and therefore he could not thoroughly go through this court, and it will be injustice. It will be an injustice. It will be failure on his part to argue without full preparation. Full stop. Accordingly, he prays for a little short adjournment. Full stop. This matter is pending since 2005. Be that as it may, as this amicus has made a prayer, the same stance allowed. List this matter on.
For
Give
Your
a
Lordship's
date.
convenience.
Give a date,
did-
not your convenience. You will to complete reading, no adjournment. Give a date.
Twenty-eighth of May.
Very well, Your Lordship.
28th of May.
Met pleasure.
Yes.
My lord, there were
Hmm.
24 accused.
Hmm.
Out of 24 accused, my lord,
Hmm.
uh, all were acquitted,
Hmm.
except the appellant before your lordship.
Okay.
But regarding 8, my lord,
Hmm.
regarding 8 accused person, rupees 500 imposed as a fine only. My lord, your lordship, no, set to go. My lord, there are 1, 2, 3, 5, 6 eyewitnesses, my lord.
What is your name?
My name is
Somed. Somed.
Somed.
Yes.
My lord, case is like this, my lord.
Hmm.
Actually, the
Hmm.
land in dispute
Hmm.
belong to the accused, my lord.
Hmm.
And that has been held by the trial court also. That is, yes, we are in possession of the land belong to us. And what happened, my lord,
Who was injured?
injury in both sides, my lord.
Dulal Uddin.
Huh?
Dulal Uddin.
Who-
This is my lord. Others, several injuries are there.
Huh.
Out of them, Dulal Uddin expired, succumbed to injuries.
This was under offenses punished, they were sentenced under section
304,
304,
my lord.
part 1,
Part 1.
for a period of
10 years.
10 years. Only one.
Only one.
Only one. Out of 24.
Who are the eyewitnesses?
Eyewitnesses, my lord, there are
My lord, eyewitnesses,
Altogether,
my lord, I am
more
giving.
than 6-7 eyewitnesses, but
Who are they?
they are the relatives of the deceased, my lord.
Hmm.
The both party came in a piece of, my lord, land, my lord. The informant, the accused side, my lord, they
So
obstructed
therefore,
the.
it was 304.
Yes,
Okay.
yes, my lord,
Hmm.
obstructed the land, my lord,
Hmm.
and put a fencing, my lord.
Hmm.
Then when the other party came, they could not go, my
Hmm.
lord. Then the quarrel.
Now,
took
why
place.
the others are acquitted?
Others.
If
are
it is a
acquitted.
group fight,
Yes, my lord, but from the evidences, it's, my lord, suggests that, my lord, a very specific, my lord, that this person, my lord, has the blow in the head, my lord, has made the blow in the head, due to which he died, my lord. It is in all the witnesses, my lord.
and what about the
Specifically,
others?
Others, my lord, they are
What
simple,
was the role attributed to them?
they are simple injuries, my lord, they are also there.
No, no, other accused.
Other accused, my lord, the judgment, whole judgment I have not read, my lord, but because this is the person, my lord, so far I have read now, my lord.
Let us see what are the charges.
Charges are, my lord, 324, 323, and also 302, my lord. 326 and also 302.
Who are the star witnesses for prosecution?
The star witnesses, my lord, the first witnesses, my lord, the 1, 2, 3, my lord, they are all in the quarrel, my lord. And they are also the victims, my lord.
Tell us, are you ready for
Well,
final hearing?
yes, so far I have read, my lord. that this-
Why you read the judgment?
Yes,
First,
now I am going
it's a,
through.
it's a criminal appeal. Why
Yes.
should you read the judgment?
Yes, that is
You
my,
should go through who are the star witnesses.
Yes.
It's a case of
Yes.
injury and murder.
Yes.
Now these are the person who
Yes.
were at the place.
Yes.
These are their witness evidences.
Yes.
And if it is a group attack, then next question will be why the others are acquitted.
And why he is, yes. That is why, madam, and one witness I have found, madam, that is PW 12, madam.
Mm.
He is an independent eyewitness, madam.
You are inside or outside?
My lord, I'm inside.
You are inside.
My lord, I'm inside
So it's important for you. Okay, you proceed, Argo.
9 months, my lord.
Huh?
1 year, 9 months. 1 year, 7 months, 22 days.
You are ready. We are going for disposal.
Yes, my lord.
You proceed.
I'm
Yes.
ready, my lord.
Yes, proceed.
So, my lord, the background of the case is like this. Disputed land is there.
No, we will not go to the background.
My lord.
See, whatever background is to be shown from the evidence,
Yes, my lord.
isn't it?
Yes, my lord.
So you first let us understand what is the first allegation. Okay? In the affair,
Yes, my lord.
then we'll see what is the search framed. Then we will go to the specifically in the given facts. Here it's a 302, then it was 304 part. No. Now, therefore, on who are the star witnesses? There are eyewitnesses. Eyewitnesses.
About
So
6
we'll first go to the eyewitnesses. Then we'll see whether they have been able to prove beyond reasonable doubt or there is any doubt is created. So therefore, background fact will go from the record. Where is the affair?
FIR. Your lordship would be pleased to take the paper book, my lord.
Yes, paper book.
Paper book, page 1, my lord.
Page 1.
Page 1, my lord. Your lordship, informant Mujibur Rahman.
Mm.
Your lordship got it.
Mm.
Informant is Mujibur Rahman.
Mm.
So, my lord, now your lordship will see the list of accused. Somet,
Just a minute. Accused.
Somet,
Hmm.
Aroz Ali.
Somed is acquitted.
My lord, only accused Somet convicted.
Somed convicted.
10 years under 302 part 1. 304 part 1.
304 part 1. Okay.
Then Aroz Ali, my lord.
Aros.
Yes.
Aros acquitted.
My lord, his imposed fine of rupees 500.
Fine. Then
Ashraf Ali.
Then
Then my lord, Rahman Ali. Shahjahan. Mormuz Ali. Shahed Ali.
yes. Just you go on reading.
So my lord, here what happened, my lord? 8% was imposed fine. I will give the name, my lord. What are these 8 persons? And others are clearly acquitted. So there remains Shemet, and so 1 person died, my lord, during trial. And others are clearly acquitted.
Yes.
Now your lordship would be pleased to take the supplementary justice. Take the supplementary suspension. Paper book, my lord. Supplementary paper book,
Just a minute.
my lord.
What you want to see?
Hello.
Supplementary.
Paper book, my lord.
Yes.
In the paper book, my lord. Your lordship will turn to page 3,
Pastry.
supplementary paper book. Simply search sheet, my lord. Ahmed Ali, Aroz Ali.
Just a minute. We're coming.
Morile kono no, Mormuz nahi.
Okay. ठीक. Okay. Yes.
So, my lord, this will be search sheet, my lord. So out of 24, my lord, one person died during trial. He is Mormuz Ali. So 20
Who died?
Mormuz Ali, my lord.
Serial number?
Serial number 8,
Serial number 8.
Mormuz Ali died.
Died.
Now, your lordship, I am giving the breakup that accused Aroz Ali, my lord.
Serial number?
I am giving it. Aroz Ali, serial number 2. Then Ashraf, serial number 3. Then Rofiqul, serial number 6.
These were convicted.
My lord.
Fine.
6, my lord. Fine. Yeah.
Fine. Who are fined? Two. Serial number 2.
Aroz Ali.
No, tell us the serial number. Serial number 2 was fine.
Serial number 2, fine.
Then
Serial number 3.
fine.
Then serial number Rofiqul, serial number 6. Then 10. Rofiqul Islam, my lord, 3. Then 4, Shahjahan Ali.
Here's the serial number.
Serial number 7.
Serial number 7. 7 also fine.
Fine. Then Shafiqul Islam, serial number 10.
Serial number 5 also fine.
Serial number 5.
Mm.
My lord, 1 minute. No, my lord.
Okay. So serial number 10 is fine then.
Serial number 10.
Mm.
Shahjahan Ali, then Shafiqul Islam. Serial number 10. Then your lordship, Saiful Islam.
11.
11.
Mm.
Then Mukhtar Ali.
13.
Mukhtar Ali, 13.
Mm.
Then Haibul.
19.
Yes, my lord.
Fine.
So total comes to, yes, my lord. Total comes to 8,
3,
subject to correction. my lord.
6. Now we are 7. One is Aroz, serial number 2, 3.
Hmm.
Then 7.
Rofiqul Islam.
Rafiqul is 6.
Yes, my lord.
Okay, fine. 8.
8, total 8.
Mm.
So-
One died.
So now, my lord,
Mormuz died.
my lord, Mormuz died.
And what happened to others? Others acquitted.
Other 14 acquitted, my lord. So 14 and 8, 22.
Mm.
One died,
Mm.
23. Somet convicted.
Okay.
So, my lord, I may give the list of acquitted person, benefit of doubt. Those are
Shopjali. Those are
So
Shopjali, my
we
lord.
did not give the dates, you just tell us who died. That's all.
Type, Mormus.
Then it's done. We have recorded it. Okay.
23, 24, my lord.
Okay, now come to the merit.
Yes. ma'am.
Yes.
So 13 persons were acquitted. Yes. So, my lord, supplementary paper book is over, my lord. Let us go
Over.
to the main paper.
Over. FIR we have read. Now, who are the star witnesses? Who are the prosecution star witnesses on the basis of
If they are
which
witnesses, my lord, your lordship will go to PW3.
he was an eyewitness? Who is PW1?
PW1 is the
Opinion.
is the
Informant.
informant. Informant. man. He is not eyewitness.
Okay. Now, who is the eyewitness? PW?
PW3, my lord.
PW3 eyewitness and other, who are other eyewitnesses?
My lord. PW3,
Hmm.
PW4,
PW4,
PW5,
PW5,
PW7,
PW7,
7, PW8,
PW8,
PW10,
PW10,
PW12,
PW12,
PW14,
PW14.
14.
Any injured eyewitnesses?
Well, among them, my lord, injured are PW. Well, that I cannot say.
Okay, we'll see later. Okay, I thought you maybe.
My lord.
Okay, now PW2 is the doctor who examined the injured or who is the
Yes, my lord.
postmortem?
PW2
Hmm.
is the doctor, my lord,
He did
Who
what? What was his role?
who first examined the
Injured.
Injured.
Okay. Just I am marking it in index
Yes, madam.
so that later on
Yes.
we need not spend too much of time.
my lord.
Then PW9 is postmortem.
PW9 is postmortem.
Okay. And who is PW11 now?
My lord, PW11, my lord.
Hmm.
He is a witness, my lord, not eyewitness.
He is also a witness.
My lord,
Okay,
doctor,
now
another
who
doctor,
is
my lord.
PW13?
PW30, Dr. Patir, my lord.
What he
He
did?
is the postmortem doctor.
No. And what about then PW4? PW13, he is PM, no? And what about PW9?
PW9. PW9, my lord. My lord,
He's a doctor.
he's a doctor, my lord. What
Who
happened?
conducted PM.
My lord, attended the deceased, my lord.
A deceased or PM?
Decision.
Huh?
He conducted the PM.
PM. And what about this PW13?
13, my lord.
13 page 41.
He is the person, madam, after GMC is, madam, when there is no sense of recovery as he was reported, madam, the patient was shifted to Dispur
Dispur.
Polyclinic, madam. The
Okay.
doctor of Dispur Polyclinic.
Dispute Polyclinic, yes.
This poor doctor. Okay, private hospital.
That's
Now, who is IO?
IO is my PW15.
IO. And who is PW16?
My lord, he submitted the search sheet, my lord.
Search sheet.
Yes.
Okay. Now, let us see the informants. Yeah.
Mujibur Rahman, my lord. Page 11.
Page 11.
May I read, my lord?
Just a minute.
My lord.
Okay, read.
Mujibur Rahman, son of Samsuddin. I am complainant of the case. I know the accused persons. Occurrence took place about 2 years ago in my.
Now, who is this? Is this Fazaruddin was examined?
My lord.
Fazaruddin.
Fazaruddin.
Because he was informed by Fazaruddin,
My lord,
not examined.
Fazar not examined.
Okay, fine.
My lord. 2 years ago, my residential compound at about 8 AM. At the time, I was about 1 kilometer away from my house. My younger brother, Fazaruddin, yes, informed me over telephone to bring a vehicle as my father Samsuddin, brother Saiful Islam, Dulaluddin, Nazrul Islam, nephew Ikramul Hussain, uncle Abdul Hakim, cousin Nurul Amin, nephew Asadul Haq, brother Mokbul Hussain, and his wife.
Mr. Sheikh,
in a vehicle.
just let us note it down. This Samsuddin died, brother
No,
Saif
Samsuddin not died. Dulal died.
Dulailed.
Yeah.
My Samsuddin was examined as
12, my lord, sorry, 14.
PW.
14.
Okay,
Possibly.
just let me read. PW for 14.
14. Yes, Samsuddin.
Okay. Okay, you proceed. You proceed.
My lord. Uncle so-and-so, my lord, Ruki wife sustained injuries caused by, now my lord, accused person, Abdul Somed, Somed Ali, Shobz Ali, Roham Ali, Rafiqul Islam, Aroz Ali, Mormuz Ali, Shahed Ali, Babul Ali, Taj Mahal Ali, Miraj Ali, Mukhtar Ali, Matob Ali, Ashraf Ali, Saiful Islam, Sofiqul Islam, Shahjahan Ali, Marfat Ali, Alimuddin, Haibul Islam, Sahara Khatun, wife of Somed Ali, Sahara Khatun, wife of Shobz Ali, Hazra Khatun, wife of Saiful Islam, Babul, alias Abu Bakr Siddiq, Hezbur Rahman, 24, total 20. With the help of thou,
Yes, proceed.
my lord, with the help of thou, Lathi, Siprang, etc. May I point it out one thing, my lord?
Yes.
That this thou, Lathi, Siprang, the offense of weapons alleged, not seized by police, not single one.
No, we'll come to that later on.
Madam.
When you will just argue,
So
this will
I,
be your points.
yes, madam. So I came with Tata Sumo vehicle and arrived at my residence after about 10-15 minutes. I have found both hands of my father, Shamsuddin, were fractured and injured all over his body. Dulaluddin sustained injuries on his head and face. Cut injury on hand and chest. Your Lordship just noticed, Dulal is the person, my lord, who died. Dulaluddin sustained injuries on his head and face. Cut injury on hand
and cyst.
Yes.
Nazrul
You
Islam
go on, you
sustained
carry on, you carry
injury
on.
on head and neck.
Hmm.
Saiful Islam sustained injury on head and shoulder. Mokbul Hussain and Fazlul Uddin sustained injury on all over his body. Ikramul Hussain sustained injury on his head. Asadul Islam sustained injury on his chest. Abdul Hakim sustained injury on his head and chest. Nurul Amin sustained injury on all over his body. Asmina Khatun sustained injury on her chest and head. Halima Khatun sustained injury on her chest and back. Rabia Khatun sustained injury on her back. Shamsuddin, Mokbul Hussain, Nazrul Islam, Dulal Uddin, Saiful Islam, Ikramul Hussain, Abdul Hakim, and Nurul Amin were taken in the vehicle to Lahorigarh Civil Hospital, and other injured were taken on Thela to hospital. Injured Dulaluddin and Nazrul were referred to Morigaon Civil Hospital. So both of them were taken to Morigaon Civil Hospital. Nazrul Islam was admitted at Morigaon Civil Hospital and Dulal was referred to GMCH Guwahati. On the same day, Dulal was admitted on GMCH Guwahati, and on the next day, doctor has told that there is no any possibility of survival of Dulal. So he was released. Then Dulaluddin was brought and admitted at Dispur Polyclinic Hospital at 4 p.m. And on the next day morning, doctor declared him dead. Postmortem examination was done at GMCH Guwahati. I have filed the Ezahar at Lahorigarh PS. Exhibit A is the said Ezahar and Exhibit 1 is my signature. Now I will cross. I cannot say what weapon used by the accused person in causing injury. There is a path on my paddy field near my house, and we were using that path to come out from my house. Accused Sobzali destroyed said path by plowing with a tractor. So a quarrel took place between my father Shamsuddin and accused Sobzali and his wife prior to the occurrence. Thereafter, all the accused person arrived there. The land upon which the occurrence took place belonged to my father and uncle Abdul Hakim. After destructing the path, Sobzali put fencing by a fishing net, restraining us in using the path. On the date of occurrence, there was no any land where the occurrence took place. There was no any, there is a seal. There was no land where the occurrence took place. It is not a fact that at the time of occurrence, there was Dhoniya cultivation at the place of occurrence. It is not a fact that we went to make a throw cultivation. Panchayat election was held after the quarrel. It is not a fact that Panchayat election was held prior to the occurrence. I am supporter of Congress party. I do not know about the accused person, which political party they support. There is a path in between the residents of Somed Ali and Mormuz Ali from Paddy Field, which ended with the main road. It is not a fact that there was no such path on the place of occurrence, and we were always using path situated between residents of Somedali and Mormudali. Our cultivable land were situated on the eastern side of the place of occurrence. There is a path about half-kilometer away from our paddy field in between the house of Fazrul Haq and Jamal Mondol, which is about half-kilometer away from our paddy field, and we used said path to carry our crops from our paddy field. That path was Sarkari path. There is a passage in between residents of Mormuzali and Somedali, through which one can go to the main road. And we sometimes carried our crops through that passage. But when they objected, we stopped to use the passage. It is not a fact that the land where occurrence took place is a disputed land and claimed by Shabjali. Under section 145 CRPC, Amar case number 48 of 2012, proceeding is pending on the said land, and that case was filed by my father Shamsuddin and uncle Abdul Hakim. It is not a fact that I have stated before police that the occurrence took place when my father arrived at the boundary of Abdul Somet, and then Abdul Somet obstructed. It is not a fact that both hands of Shamsuddin was not, that Shamsuddin did not sustain injury on his head. It is not a fact that Nazrul Islam did not sustain injury on his head. It is not a fact that any person sustained injury except Shamsuddin, Saiful Islam, Mokbul Hussain, Nazrul Islam, and Dulal Uddin. Our land situated near the place of occurrence is government land. I do not know if the father of Shabjali purchased the said land where occurrence took place by registered deed from Shuren Deka and Shosin Deka. It is not a fact that the land in which occurrence took place was in possession of Somor Ali, father of accused Shabjali and Rahmali, during his lifetime since 1975, and after that Shabjali and Rahmali. It is not a fact that we never possessed the land on which the occurrence took place, and it did not belong to us. On the day of occurrence, Shabjali and his wife put fencing on the boundary of the land where occurrence took place. It is not a fact that Rabia informed my father about putting fencing by the accused Shabjali and his wife. The occurrence took place when my father arrived near fencing. When my father raised alarm, my brothers named above, uncle, nephew, sister-in-law, came out and gathered at the place of occurrence. It is not a fact that my said brothers, uncle, sister-in-law beat Shabjali and his wife. The residents of accused persons situated near the place of occurrence, and they are related to Shabjali. Residents of Abu Bakr, Elias Babul, and Hibdur Rahman were situated half-kilometer away from the place of occurrence. The shouting of quarrel cannot be heard from their residences, but it can be heard from the residents of the accused persons who were related to Shabjali. It is not a fact that Shabjali shouted on the hearing the other accused person came. The quarrel started when my father was coming through the path and could not proceed due to fencing put by Shabjali, and raised objection by saying that why Shabjali put fencing. My brother and uncles arrived there when my father was assaulted. My brother did not assault any accused person as they were coming with bare hand, but the accused assaulted them as they were armed with weapons. Shabjali filed a case against Shamsuddin, Mokbul Hussain, Saiful Islam, Mohibur Rahman, Fazrul Islam, Nazrul Islam, Dulal, Ikramul, Zahirul, Nurul Amin, Asadul Haq, Rafiqul Islam, Mufidul Islam. It is not a fact that 7 accused persons sustained injury.
Yes.
my lord. It is completed, my lord.
Hmm.
Informant is complete.
Hmm.
Now, possibly, my lord,
PW2.
PW2.
Hmm.
PW2, he is Dr. Nurul Amin.
He was the person who first attended, immediately after the incident. I think
Injured
local
person.
hospital.
Injured persons. On 30/12/2011, I was at Lahorigarh PS as SDM and HO on that day. At 10:25 AM, I examined Muhammad Rafiqul Islam, 25 years, son of Shabjali. Your Lordship, would you please, may I say, my lord, that Rafiqul is accused group, my lord. So what was the injury, my lord? Right thumb on medical aspect, distant phalanx 1 centimeter, so and so out, incised looking. A cut injury, my lord. Now, your Lordship, on that day, I also examined Haibul Islam. He is also accused, my lord. 25 years son of Hormuz Ali. Injury is tender swollen right mid arm, others. Simple injury. On that day, I also examined Marfat Ali, accused, my lord. Number 3, Marfat Ali, son of Aroz Ali. An injury was tender left mandible, others so and so. That on that day, I also examined Aroz Ali, another accused, my lord. And left forearm laterally aversion, others NDA. Now 5, my lord, Shah Jahan, he also accused, my lord, 25 years, son of surgery. Abrasion left upper optical region. Upper optical region. Now, abrasion, another person, my lord, he is Shabjali. He is also accused, my lord. And abrasion left mandibular area. That also examine Shamsuddin. Now, your Lordship, remaining persons, my lord, they are the informants group.
Hmm.
From Shamsuddin, it starts.
Hmm.
Shamsuddin, 70 years, tender both soldier.
Both party got injured.
Both party. Our 6 persons were injured. They
But
were examined by
so far
doctor.
relating to this present appellant,
My lord.
witnesses say that he used the Ciprang.
He used the Ciprang
Ciprang
on the head of the
Head of Dulal.
Dulal.
Others are free fight.
Free fight.
Specific is,
Yes.
and therefore he has been condemned.
Others also admitted
And my
that
lord,
the victims, my lord, they have also admitted that since their chaos, my lord, so we could not say
We
who
could
is-
not identify the
who is
others.
not others, but.
So
but it
benefit
is
of
very
doubt was given to
specifically
the
stated
others.
Dulal, everyone.
And the injured who, some other injured who had minor injuries like this, they named who assaulted them, those persons were given fine. Is not it? Yes. So Dulal, this Samed or what is Samed?
Samed Ali.
Somed's conviction is based on the witness's testimony that he used the Ciprang
on the head of
on the head of the.
This
Pulse.
is
Now, what the injury and postmortem report said, Somed's
supporting the,
no, injury is found.
supporting.
Injury is
what is your case? What is your argument?
my argument.
Just summarize, we will go details.
My argument is, first one is this, my lord. The Ciprang was used.
Ciprang was not recovered.
Ciprang was not recovered.
Okay.
And actually, my lord, witness number 10, eyewitness 10, my lord, he said that a pitch of wood was used to hit Dulab.
Okay,
I will point it out from the judgment, my lord. Learned trial court, my lord, mention all the eyewitnesses who said that Siprang was used, but learned trial judge did not say anything about this
PW10.
wood used by 10.
PW10.
Regarding wood, it is not said. Nothing has been said. That is, learned trial judge, I'll go to that judgment, my lord. Learned trial judge sidetracked
Okay,
the use of wood. Now, my submission before your lordship is this. If the eyewitnesses say, some eyewitnesses say Siprang, some eyewitnesses say it is the Hunti.
Mm.
Another witness say that wood. If this evidence, PW10 demolished everything. Because everybody looked into the heating by wood, by Siprang.
Siprang.
But somebody said that I have seen that it was hit by wood. And that was sidetracked by the learned. Now, another thing is this, my lord. Here was a mutual market that is on record. And injury also says that there was market. Because, my lord, from accused side, medical examination.
The
said that
prosecution witness itself says that these are the person from accused side, they also got injured.
six persons. 6 persons, not that 1 or 2. 6 persons from accused side got injury. And they also, from informant side also, they got injury. 3, 4 persons or 5 persons. It clearly proved there was a mutual market. Nobody can deny it. Now, your lordship, we have to go why there is mutual market. Who is responsible for this market? Learned trial court clearly said that the informant party is the aggressor. I'll point out that judgment, that paragraph. Informant party is the aggressor. Another vital point is this: land belongs to whom? We have exhibited some Jamabandi copy, purchased it, and ultimately, my lord, learned trial court pleased to help that land belong to us. We have better title than the informant group.
So therefore, they are said to be aggressor. Since it's your land, they have
Yes.
come, that's right.
Yes, sir.
Yes.
That the access of land was in our possession, that is also fined by the learned trial court. Only problem is this, my lord. The Somed is targeted. Somed is targeted by all the witnesses. But thing is this, my lord, if we get some option of contradiction regarding this, and that is the main contradiction is one witness, eyewitness said, their witness, that wood was used, meaning thereby that Siprang was not seized by police, wood also not seized by police, lathi was not seized by police. Then who assaulted, in what circumstances? And we adduce some defense witnesses, your lordship. In the defense witnesses, my lord, we said that actually one accused person went to the place of occurrence and there was dashing and pushing. He fell down on the ground. He is Arozali. And Arozali happened to be maternal uncle of Dulab. Then Mokbul, what he did at the time of Marpit, Mokbul by a wooden batam attempted to assault Arozali. Then Dulal found that it will be dangerous if Aroz is hit by batam, then Aroz will die because Aroz is a bit elderly person. Not that so much old, but in the middle-aged person, and he related to Dulal. Finding that Aroz will die if the hit goes to him. Immediately he went there, tried to pull up Aroz Ali from the ground. Then the heat of batam fall on the head of Dulal. Mokbul, brother of Dulal, attempted to assault Aroz Ali, and the heat fall on the backside of the head of Dulal, and ultimately that sustained injury. Now, your lordship, how are police sustained? Because if we go to evidence of PW 10 eyewitness, that on batam was used. Batam is in the field. When batam is in the field, who used this batam? Not Somen. Our case is this Mokbul used this batam. And that is why batam was used in the Marpit. And batam was looked by PW 10. And that is why he said assault was made by batam. And our case is this, batam was used by Mokbul to his Aroz Ali, and wrongly it is hitted Dulal from that side.
Yes. So your basic case is
My lord.
that it is established that there was a marpit. Now, however, a doubt is created so far relating to the weapon used first, because one of the prosecution itself says it was a batam by which the victim got injury, and other witnesses said it is a rod, and the no weapon used in the offense was recovered. Therefore, a doubt is created so far regulatedly use of the weapon. And who used this? So therefore, it should be a case of acquittal.
Doubtful.
That is the case.
Doubt, yes, madam. And your lordship would be pleased to see,
And other
they
parties.
said,
Hmm.
another, subject to correction, my lord, what your lordship will take. Actually, they sometimes say Sipram.
Hmm.
Sipram is one thing. Another eyewitness say it is a khunti.
Hmm.
Sipram, if we noticed, why I am pointing out your lordship, because eyewitness seen, equally seen. So if eyewitness equally seen, then Sipram should be Sipram always. Sipram should be Sipram always. It should not be khunti. And another thing is, your lordship, one witness says Sipram with wooden handle.
But how will you explain that all the witnesses, those who were present, says that it is the you who has given the fatal blow?
Either by Sipram or by
Whatsoever,
khunti.
but fatal
But-
blow is given by you. This remain consistent.
Now your lordship would be pleased to see. So many accused persons
Hmm.
were injured.
Hmm.
Injury report is there.
Hmm.
But Somed did not get any injury.
We, okay.
Yes, my lord. Somet has got no injury. Now my humble submission before your lordship, Somet seems to be from the entire case, my lord.
Yes.
It seems that other witnesses, other accused persons are small hills. Somet is the Himalaya.
Superman.
He is Superman. So, my lord, if Somet, taking into consideration all evidence, if Somet is the Superman, a single touch was not given to Somet. It goes to show that Somet was not in the place. Because, my lord, I humbly submit.
Was
If-
it your challenge, the defense case that Sumesh was not in the place?
Yes, I have given
Suggestion?
defense witness, my lord.
No,
Defense
defense
witness
witness is
stated.
different. What is your case projected during the examination of PWs? This is not the case.
My lord.
Your case is that, your whole case is that land belongs to us, there is a land dispute. There is a 145 proceeding.
lord.
Now on that day, we have not done anything. They have put some fencing nets and all. And that's why a quarrel started. There is no dispute. In defense case also quarrel is there.
Now, your lordship,
Mm.
we given evidence
Mm.
of LAB that I was not present there.
Giving evidence of LAB is one thing and creating a defense case is one thing.
My lord.
That you require. You
that is-
cannot give by surprise that this
My
is.
lord, that is rightly pointed out to your lordship that I was not present.
Mm.
I did not put that question. to
During
PWC.
the.
Yes. So, my lord, sum total, this is the case. Your lordship
Sum
very well-
total case is that these are the witnesses
My lord.
who named you, but whether on the basis of their evidences,
Yes, eyewitnesses, my lord.
eyewitnesses,
Ah,
and some were said to be injured eyewitnesses, whether you have been rightly convicted
yes.
or you ought to have been acquitted on the ground, basically no weapons were recovered.
Yes.
Number two is that there is a doubt as regards the weapon used because some said it is wood, some said it's kukri, some said it's spring, more particularly used by Somed. And other says these are the kukris and spring and with kukri with wooden handle.
So, my lord, my humble submission before your lordship is this.
Mm.
That ultimately, injury was sustained.
Mm.
Dulal died. There is no
No, this is
dispute at
established.
all. Now, thing is
And
this, my lord, how
Dulal
Dulal
also died for the injury which was inflicted on the date of and place of occurrence. But now the question is who inflicted the injury? That is the issue. Others are established.
And now, your lordship,
Mm.
if Somed assaulted
Mm.
either by Siprang
Mm.
or by Kutne or by wooden pattern. But one person, another thing your lordship will see. The PW said that many injuries on the body of Dulal.
Mm.
PW1 says
Mm.
that Dulal got injuries in the face, in chest.
Mm.
May I read that portion, madam? Your
Yeah,
lordship already.
yes, absolutely.
Injury in the body.
Whole body.
Different parts,
Mm.
whole body.
Now what the PM says, you will argue that only single injury,
All injury. So, my lord, my humble submission before your
not
lordship.
trustworthy.
Yes, my lord.
PW1
My
is
lord.
not trustworthy.
Now, admitting that yes, Somed, there is a volley of witnesses, eyewitnesses that Somed assaulted. Okay. Now, thing is this, Somed cannot assault by these weapons, either of one Siprang, another is Kunti, another is Bata. So doubt created. That's the thing.
Anything
Well,
on that
and-
point,
and-
any judgment you want to rely
My lord,
as regards that weapon?
that-
That when there is a doubt so far relating to the weapon used, doubt itself is created as regards the who inflicted the injury.
My lord, on that line, my lord, I humbly submit before your
Okay,
lordship.
okay, anyway, just I have
Do
asked.
not, do
Let
not
us
have,
first hear for
do
some
not
time.
have that point, but
Anything to be
another
added
thing
on
is-
legal issues?
legal issues is this. Total 24%.
Okay.
And out of two groups, my lord, it is on the judgment itself that there were 33 to 35 persons gathered on the place of occurrence. And as your lordship pointed out that yes, Somet committed this offense. There is evidence, eyewitnesses, everybody is saying. I could not demolish their evidence. Now, my lord, my humble submission on point is this, my lord. As on record, there is dispute regarding land. Land belong to us. And title is also belong to us. 30 to 35% gathered there. 8% only convicted for 500 rupees. Other 14 acquitted. Now, under that circumstances, my lord, if I am not, my lord, alternatively, I am submitting before your lordship. If I am not acquitted on benefit of doubt, if it is done, then well and good. But another leg of argument to your lordship is this, whether the case can be considered under 304 part 2. Because why I am saying, my lord,
This is conviction under 304,
Part 1.
part 1.
part 1,
Okay.
life and extended to 10 years. But if I go to your lordship considered under 304 part 2, then punishment can be extended up to 10 years. Taking the entire circumstances, my lord. Taking the entire circumstances, that Somet is not the starter of the quarrel. Somet is not the person who started the quarrel. Quarrel started between Shobjali, his wife. They were putting some net fencing. And there, another group, my lord, came there, quarrel started. Thereafter, Somet may be there. But Somet did not started the quarrel. And ultimately, 33 to 35% gathered there. And all were acquitted, except Somet, my lord, considering these entire circumstances, my lord. Your lordship may be pleased to take the case under 304 part 2. And in that case, my lord, your lordship can consider my sentence.
Yes.
Because, my lord, already I have gone to spend in custody for 1 year, 7 months, 22 days, my lord.
Okay.
So, my lord, only one thing, my lord, I have a family, I'm an old person, my lord. And another thing is this, my lord, it is not a murder. It is not a case that somebody with intention killed it. With intention is not there. Knowledge may be there that why you use this Sipram. You should be careful to use the weapon. So, my lord, my humble submission before your lordship, if invoking 304, some relief may be granted to me.
Yes.
My lord, supposing, my lord, already I have about 2 years in jail. And also for another some time, my lord, let me remain in jail. If it is not acquitted at all,
Yes.
that is my last
Alternative argument.
alternative submission before your lordship, considering the entire facts and circumstances of the
Yes.
case.
Yes.
Yeah, oblige, your lordship.
PP.
First, my lord, regarding the
for part one, my lord. The knowledge I have found from the, my lord, what I have, my submission from the evidences, my lord. My knowledge and intention is very much there, my lord. For my lord, because from the evidence, my lord, one of the evidence I have found, my lord, he is the person who first initiated the couple, my lord. He called his sons from one of the witnesses I have found, my lord.
Mm,
He called his sons to the place of occurrence, my lord.
Just a minute. So he had the knowledge.
Yes, he has the knowledge and also intention.
Okay.
And your lordship, and the other injuries was the, since the group fight, my lord, your lordship will see, my lord, other injuries that were inflicted are simple, my lord. They are only on the
Simple.
sudden fight they have made this, my lord, assault, my lord. But out of them, my lord, his intention is very much to be, my lord, and he is also carrying a weapon that is, my lord, weapon of offense that is, has been, my lord, come out from the evidence, my lord. Is a, my lord, iron weapon, my lord, and he has very much knowledge that if he hit with in the occipital region, my lord, it is most likely to cause death, my lord. He has not hit it in the other with that, my lord. That is one part regarding that. And now coming to the, my lord, injuries, my lord.
But he has given the blow, almost all
all
the
the,
witnesses
and coming
said
from
that.
the, my lord, yes, I will not read all the
I would
witness.
say about PW 10 and that he's saying different witnesses is different weapons.
Yes,
How you,
that, yes, that part, my lord, that
we'll
part, your
come
lord-
back at two here,
Yes.
just will understand.
Yes, yes, that part your lordship may kindly come to just before the other part I will submit later. There's lordship's
Mm.
query, my lord. Lordship may kindly come to PW 14, my lord.
PW 14.
14, my lord.
44.
Yes, my lord. Page 48, my lord.
Yes.
Just the front portion is, my lord, similar, my lord. Yes, just I want to ascertain this, my lord. Lordship may kindly come to the from the 6th line I am reading, my lord. They all fence the way to my house, as your lord. It is
Space,
one
space, cross.
page 44, my lord.
Yes.
Shift part, my lord.
Okay.
Page 44, lord. 1, 2, 3, 4, 5, 6. 7th line, my lord. They all fence the way to my house. Accused Samed and Mazed made a call, and then his sons, namely accused Samed, Ashraf, Shahjahan, Araz, Safikul, Mukhtar, the name of the rest I've forgotten. There are about 30 to 35 people and they assaulted me. Accused Samed, Ashraf, Mukhtar, all Shahjahan, Habibur were assaulted me. Accused Samad assaulted me by Khanti and others by Lathi. That is, my lord, this Samad is carrying the Khanti, my lord, that is specific, my lord. That he has also assaulted Samsuddin, my lord. That your lordship will find. Along by Samad, my lord. That is one part. Then next, my lord, then I raise alarm, and my sons Dulal, Saiful, Fazrul, and others, my lord, they came. My son Dulal was assaulted by Ashraf Ali, Samed, Araz Ali, and with Khanti Siprang. The hand of the Siprang was of wood. That may lordship may kindly note, my lord.
Page.
Page, my lord, 44, my lord, the
Uh.
last part of the evidence, my lord, of Samsuddin, my lord. Your lordship will find, my lord,
My son.
from below, my lord, is 4th line, my lord. The hand of the Siprang was of wood. So, your lordship, he might.
He clarified. According to his clarified that
Yes.
it is the weapon, and he also
Yes.
said Khanti within bracket
Yes,
Siprang.
well, yes, it is the handle is made of wood, my lord. So it might be, my lord, he has assaulted in a manner from the back, my lord. So that is one case. All my sons were assaulted by accused person. Other village people assembled there and
See, and they, and others are similar, my, the evidences. That is what, I want to state, my lord, regarding the wood part, my lord, because it has also carry a handle of wood, my lord, with the weapon of offense, my lord. And regarding one thing that my understanding state,
Sorry.
no, regarding another thing, man, that the whether the weapon was recovered or not, that has also been clarified, my lord. Your lordship will find from the yes, your lordship will find from the evidence of PW 15 IO, my lord.
Mm.
He has made the endeavor to search for the weapon, but he could not find it,
Weapon,
and therefore, and it is
weapon,
not a
weapon
fatal,
is
my lord.
not always
Always fatal.
of not fatal, more
Um,
particularly when injured victims are
Yes,
there.
yes.
That is not fatal.
Fatal, my lord. These are two parts, my lord, where the doubts are clear. And other evidences, my lord, if your losses one by one, I'll take, just I'll main.
The only thing is here is there is a free fight.
Free.
That is established.
Yes, sir.
There is a land dispute, free fight, 35 people, both sides got injured.
Both from.
This is established. Out of them, one died.
One.
And in the free fight, there was it is also established that fatal blow was given by Summit. Summit, that is also there.
Yeah.
Now, it is not 302,
Not 302.
not 302. If not 302, now it comes to be 304
4,
part
1 or
One.
2.
or part 1 or
Part two.
part 2. If part 1, we appeal the conviction. If part 2,
What?
we will think of the
No,
sentence. That's all.
let's think of
Come
that.
back at 2. We'll dictate the order at 2. Not 2, after hearing it.
Yes.
We'll conclude, we'll not make it serious.
Loss.
Only one thing, but
Yes.
what my learned friend said that there was intention.
Hmm.
I humbly submit before your lordship.
Hmm.
If we distinguished between intention and
Whether that intention was originally there or that happened at the spur of a moment with between the fights. What the evidence is? If it is a spur of a moment, suddenly hit it
Hmm.
and
yes.
then maybe, we do not know.
Now,
We'll come back.
We'll
At
come
2
back.
we are coming back. And we'll dictate this order. We'll not keep it
Yes.
sealed.
much of it.
Yes,
May I go to the, my lord, the evidence part now, my lord?
yes.
When I read the whole evidence or just pick out the main points, my lord?
Because reading all
Yes,
this
no, my lord.
very long evidence
Yes,
cross also
yes.
it's not
Just I am picking out the main,
main.
my lord, my lord. PW1 is, my lord, that is the informant, my lord. I am skipping it because
He was not present. He was informed
he came later on, my lord.
later.
Thereafter, he was given the. So, and his evidence also, my lord,
How many
supported by the
other methods are left today?
hearing matters.
Huh?
Hearing or 3 matters are there.
Doubtful because we will dictate this order.
Yes.
Like to appear in 31.
Huh? 3 minutes. We do not know if time permits will start, but after completing this will not keep it as a CF, we will continue dictating this order. Yes.
In the evidence laid down by PW1, my lord, it is also corroborated by other witnesses that I am just pointing out to your lordships, my lord. Thereafter, my lord, PW2, my lord. PW.
PW2 more,
Yes.
but PW2, I
the
do not
matter-
think that PW2 did PW2 examine the deceased.
Yes,
Where is that?
that is, my lord. In the, my lord, page number 17, my lord.
Okay.
That is what I want to point out, right?
But in all other all other victims, my lord,
Or simple,
simple injury.
simple, I have marked it.
Yes, my lordship may kindly come page number 17 to the last portion, my lord.
Hmm.
On that day, I also examined.
Okay, Dulal Hussain.
Yes. Yes, my lord. Son of Samsudin, lacerated on occipital region.
Hmm.
Patient was unconscious. Inference, grievous injury caused by blunt weapon. So here also, my lord,
Hmm.
the evidence is that in the occipital region,
Hmm.
he was given the blow. Yes, blunt, blunt. Next, your lordship. And your lordship may kindly turn to my lord PW3 also. Page 19, my lord, of the paper book.
Dulaluddin on his head by a Siprang.
Yes, ma'am. My lord, in the middle portion, my
Middle
lord,
portion.
accused Samsud Ali hurt Samed Ali hurt Dulaluddin on his head by Siprang. Accused and others are injured, my lord.
Accused Samsed Ali hurt to
Dulal.
Dulali head is ringing.
It is Siprang, my lord.
Okay.
On his head, there also, my lord.
Yes.
And my lord, in the cross part also, he denied the solution that was made to him, my lord.
Yes, reaffirm.
Yes, he has
At
reaffirmed
page
the-
21.
Yes, he has reaffirmed in the everything, my lord.
Mr. Sheikh, cross is brilliant.
Lord.
Cross is brilliant. Reaffirm everything.
Lord.
Yes.
Thereafter, my lord, PW4 also, your lordship will find at the middle portion.
Page.
Page, my lord, 23.
Okay.
And
Accused Samed Ali assaulted
assaulted
Dulaluddin by Siprang on his head.
head. That is also. And yes, my lord. And thereafter, my lord, PW5 I am skipping, my lord, PW6, my lord. Though he has not seen, my lord.
Just
Here,
have you noted it down who are the eyewitnesses?
eyewitnesses, yes, my lord. This,
I'll ask you later on.
yes,
Because I have marked something, I'll have
Yes,
to confirm it. Yes. Page
now
24.
page, my lord, 27, my lord. There's
Page-
PW6.
Page 27, PW6.
PW6, my lord. Here also, my lord, though he is not an eyewitness, in the middle portion, your lordship will find, my lord. Samsudin told me that accused Samed Ali caused hurt to his son Dulaluddin on his head. Yeah.
Page 20.
Page, my lord, PW6, page 27.
Yes.
And also may kindly come to the chief part, middle portion. Samsudin told me that accused Samed Ali caused hurt to his son Dulaluddin on his head.
Okay.
Yes, it is. And also, my lord, next, your lordship will find 28, page
Yes.
28. That also, my lord, lordship may kind to just in the middle portion, my lord. Samsudin got fracture in both hands. Dulal also came, assaulted his father. Samed Ali assaulted Dulaluddin on his head by pickets, Kunti. And Kunti and Siprang, both are similar.
Synonyms.
Synonym.
Siprang is a little bit bigger.
bit,
Yes, Mr. Das, what you say?
No, there's Siprang, my lord, that is not the Siprang we used to say, my lord, in Assamese, my lord. It is a different weapon. It is somewhat, I have.
In Assamese, Siprang and Khonti there.
Very much might is not a
Yes.
weapon. It's not a Khonti, my lord. That is, this Khonti is, my lord, in their language, it is more.
It's
of a,
kind
my
of
lord,
Part is made of iron.
Hmm.
While Khunti has been steel handle.
Yes. It is my PW7. Now, my lordship may kindly come to cross part, my lord.
Yes.
Here, summarily, your lordship will find in page 29, my lord,
Yes.
in the first paragraph later part, my lord.
Hmm.
He is the person who first initiated, my lord. Somed Ali first started Marpit and assaulted Dulaluddin. Subzali assaulted Samsuddin, Hizbur, and other things like that. my lord.
Hmm.
That submission I made, my lord, that he has prior intention, my lord,
Hmm.
that he has first started the Marpit and he has called his son to join the Marpit. This is corroborated by PW 14 statement is corroborated by PW 7, my lord. The middle portion, my lord.
Hmm.
And you in the statement of PW
Page
14 also.
31 is
Yes, ma'am.
PW 8,
That is, yes, some should has your lordship got 29, your lordship has got it, my lord.
29.
29 may cross
Yes,
part. my lord.
Samed Ali first started
Yes, yes.
Marpit and
Yeah,
assaulted.
that is my lord,
Dulal-
corroborated by the statement of PW 14, my lord.
Hmm.
He also stated that that Samed Ali first started and he called his son to join.
Hmm.
Yes. And then my lord, PW 8, my lord.
Hmm.
It is also my lord,
Samed Ali assaulted Dulaluddin on his head by Siprang.
Siprang, my lord. And in cross also, my it was reaffirmed, my lord. Their own police. Samed Ali assaulted Dulal on his head by Siprang.
This is at page 31.
Yes, my page 31, my lord.
Hmm.
Another thing I have seen here, my lord. Mm. That it carries a wooden handle, my lord. That is this. Oh, I'm skipping it. I will show it, my lord, later. My lord.
Yes.
That carries a, my lord, in cross part, my lord.
Hmm.
And my lord, may kindly come to now, my lord, PW my lord,
Nine.
9, my lord.
Okay.
PW 9 is the, my lord, the my lord, doctor who has made the postmortem report.
Hmm.
Here your lordship will find page 34, lordship. Page 34 in the from top, my lord,
Hmm.
the injuries, my lord. As stitches own, and the second line, my lord, on removal of the stitches, margins are found contused. Adjacent areas of scalp is contused, covering an area of 4 into 2.5 centimeter over occipital region, my lord. The skull underneath the said scalp found fractured, depressed, and communicated. Contusion of size such over right temporoparietal region 4 centimeter. The right ear. That is also in the portion of the head. Here also underneath skull found fractured, depressed, communicated. 1 and 2 injuries. Your lordship may kindly come to below portion opinion as to the cause of death.
Date.
Death was due to coma as a result of injuries sustained on head. All injuries were antemortem and caused by heavy blunt object and is homicidal in nature. And my lord, lordship may kindly come to the cross part also, page 35, my lord.
Hmm.
My lord. The injury, a heavy stick of wood, iron, wooden pulp, hammer, etc. are heavy blunt weapon. That is, yes, specified, my lord. This injury unlikely be caused by falling on hard substance, but such injury cannot be ruled out also. Next line, my lord. The said fracture over the skull may be caused by assault with heavy bamboo stick. That is, my lord, the injury is affirmed by the when the suggestion is put to him. My lord. I have found injuries on head region in two places. Your lordship will, why I am saying this about it, the two injuries in the head, my lord. In the spur of the moment, you can hit once, my lord, but you have hit in the occipital region, my lord, 2 times, my lord. With all the knowledge, my lord. Now, silent. Others. 10. Now, your lordship may kindly come to page 39, my lord. He is the, my lord, star witness and is an independent witness, my lord. PW 12, my lord. I am reading just a small, my lord.
Just a minute.
Yes, yes, ma'am.
I have a PW.
PW 12, my lord, page 39, my lord. He is an independent eyewitness, my lord, not the injured witnesses. I know the accused person and this is the occurrence took place about 3 years ago at Paddy Field of Samsuni. At the time I was in my house. I have heard the incident from some boys and girls and then I went to the place of occurrence. I have seen that Samsudin was gherowed by Samed Ali, Ashraf, Safiqul, Saiful, Shahjahan, Sabzali, Rahim, Azizul and others. Samed Ali assaulted Dulaluddin by an iron khanti. This is important, man.
PW 12.
PW 12, my lord. He is an independent eyewitness.
Not part of the fighting group.
Not part of the fighting group. He is very vital. Samed Ali assaulted Dulaluddin by iron khanti and he sustained injury on his head, my lord. The injury is also specified on his head. There are other witnesses are similar, my lord. Your lordship will,
He has denied the
Yes.
suggestion.
yes, denied the lordship will come to in the middle portion, my lord. It is not a fact that Maqbul attempted to assault Irazali and Dulal tried to save him. Assault of Maqbul fell on the head of, as a result, sustained injury. In the middle portion.
Middle portion. I have
Yeah.
not, it is
It
not
is
a
not a
fact.
fact that Maqbul, it is stated that, my lord, that somebody tried to, my lord, rescue him, therefore the blow, that is not a fact, my lord, that he has, my lord. Okay. And PW 14, my lord, I have read, my lord, in the first instance, my lord, that I am skipping, my lord.
Which
Here-
PW 13?
13 is, my lord, he is the, my lord, Dispur Polyclinic doctor,
Okay.
my lord. My lord, he was under treatment, Surgeon BK Bush. He was admitted on 31/12/2012, 2011. On the following, the patient died and have given the death certificate on the consultant of. Patient was
It's not
admitted.
very relevant.
Yes.
These are shifted.
Yes, my lord. One line, my lord, it is injury, the middle portion, my lord.
Hmm.
Patient was admitted for head injury. Already diagnosis treatment was done by BK. I only gave death certificate. Patient
Hmm.
suffered traumatic head injury. Thereafter, my lord, 14, my lord, 14 also the accused Samed Ali assaulted me by Kunti and others. Then there is also the assault by Samed with a Kunti. That is also, my lord, stated in a chief part, my lord, below part. My son Dulal was assaulted by Ashraf Ali and Samed Ali with Khanti Siprang. Handle of Siprang was of wood. All my sons were assaulted by accused persons. Here your lordship will find that in the 1, 2, 3, 4, 5, 6th line, my lord, your lordship will find accused Samed and Mazid made a call
Cross.
and then,
You are saying about cross?
no, my lord, chief part, my lord, that
Page
he has-
44.
page 44, my lord,
Ah.
in a 6th line, my lord. Accused Samed and Mazid made a call and then his sons, namely
Hmm.
Samed, Ashraf and others joined, my lord. That is why he is convicted, my lord. He is a prime accused.
Hmm.
IO's witness also might remain unshaken in the cross part, my lord. Item PW 15.
PW.
PW 15, my lord. He also stated what has been stated, my lord, the similar way.
PW 1514. Yes.
Page 50, the cross part, my lord.
Hmm.
There also, my lord.
Who is he?
He is the, my lord,
Pulvora. SI.
IO, SI. Lordship will kindly come to 50 or page 51, my lord.
Hmm.
My lord, on 10-1, third line, my lord. 10-1.
Page 51.
Yes, my lord. This is a cross part line.
Hmm.
10-1-2012, two
Hmm.
numbers of accused persons, namely Abu Bakr and Hafizur Rahman, were arrested. Their names are not in the FIRs of 16 accused got anticipated bail from Guwahati High Court. On such and such day, I examined 11 numbers of witnesses. On such and such 4 numbers of witnesses were examined. Exhibit 6, the sketch map, no scale is used to show the distances and place of occurrence. No blood is found on the spot, no seizure is made. I have also searched for weapons used in the offense, my lord, that is, my lord, but not found anywhere. He is given an explanation, my lord, why he has not. Because of this, no seizure is made. Witnesses Mujibur Rahman has stated before me that he was not at place. And no suggestion after that was given to him, nothing was confronted. My lord. These are the, my lord, evidences so far, my lord. Yeah, now, my lord,
Hmm.
evidences are almost complete, and my lord, lordship has seen, my lord, in cross also their evidence remain unshaken, my lord. Now, my lord, it comes the stage of, my lord, 313 stage, my lord.
Hmm.
May I take it, lordship, to page
Yes.
61, my lord?
Page 61.
Yes, my lord. Page 61 also, my lord, I have read all the questions put to him, my lord, and he has no any
Explanation. Yes, yes,
explanation.
denied.
He has only said it false, 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 my lord. And I have also seen the specifically, my lord, others, though I am not placing now, my lord, that is, my lord, regarding PW 12.
Hmm.
That is the independent eyewitnesses. That Halima Khatun in her evidence stated that on being informed, she went to the place of she has been Samsudin being harassed by you and other accused persons. This question is put to him, my lord. There also he stated only false, my lord. He has not raised any whether he has any or say
Anything,
uh,
in defense
anything.
case is also he has said almost positive. There is no
False.
quarrel.
No
But
quarrel.
defense case is that there was a quarrel, there is
Yes,
a
quarrel.
dhania, as regards dhania
Yes,
cultivation.
yes,
So somebody hit
Yes.
somebody fell down, then that blow
yes,
hit this
yes.
disease.
And this, he could have made some, my lord, reply that, no, that she is an interested witness, that she has enmity, nothing of sort that was brought before, my lord, in 313, my lord.
Yes.
So his, and for PW 12, my lord, eyewitness
Hmm.
statement remains totally my convinced man unshaken. Now, going by the witnesses, my lord, and so far, my lord. So I think, my lord, in my humble submission, my lord,
Hmm.
he is rightly convicted, my lord, under, right, my, he should have been, my lord, I think, my lord, should have been 302, my lord. Perhaps he is a lenient punishment, my lord. Because your lordship will find, my lord, this spur of the moment, my lord, in a group class, my lord, once you have made a blow in your head, my lord, at least he should restrain himself. But no, my lord, he has made another blow. Because in the postmortem, your lordship will find 2 blows in his head. And that is, and 2 fractures, my lord. This is the what my learned senior friend has, my lord, stated, my lord, regarding the knowledge part, and also regarding other things, my lord, wooden part I have explained, my lord. And now, my lord, whether lordship has made a query whether that can be converted, whether we can convert it. On that, my lord, I have, there's one judgment, my that I have. That I have marked, lordship will kindly take. This is a short judgment, my lord, but the judgment is squarely covers, my lord, every fact is identical, my lord. From the head note, my lord, 2-page judgment, my lord. I'm just reading from the head note, my lord. Then your lordship may kindly come to from paragraph 1 I am reading, my lord.
Yes, read it.
Feeling aggrieved and dissatisfied with the impugned judgment and order dated 18/11/2008 passed by the High Court of Madhya Pradesh Judicature at Jabalpur, bench at Gwalior in Criminal Appeal number 43 of 1997, whereby the High Court has partly allowed the said appeal before by the original accused and set aside the judgment and order of conviction and sentence dated 16/1/97 passed by learned trial court, whereby the learned trial court convicted the respondent original accused for commission of the offense under section 148, 302/149, 325/149, 323/149 of the Penal Code 1860 and altered the conviction of accused Ram Avatar from section 302/149 IPC to section 304 part 2 IPC. and sentence him to 5 years rigorous imprisonment with fine of rupees 5,000 and set aside his conviction for the offence under section 148 and 302/149 IPC. Altered the conviction of the accused Kali Charan to offences under section 323, 325 IPC and reduced the sentence to the period already undergone. Set aside the conviction of the accused Amar Singh, Kedar, Abhilekh Ramgopal under section 148, 302/149, 325/149 and 323/149 IPC and acquitted them from the charges leveled against them. Set aside the conviction of the accused Tej Singh Gangaram Bhedari under section 148, 302, 149, 325, 149 IPC and convicted them for commission of the offence under section 323 IPC. And High Court has, my lord, first reversal. Thereafter, my lord, paragraph 3, your lordship may kindly come, my lord. Now, so far as your lordship got it, my lord. Now, for,
My problem is that I have already read whole
Yes,
judgment, whole the
ma'am.
judgment.
yes. Your lordship, since I am not repeating, my lord.
No, so I have read this.
Yes. ma'am.
When you are reading, I have completed.
Lordship. So that.
More
various-
particularly, you are relying in that,
Paragraph
this is
3, 3
the
and,
last part.
yes, my 3 and my lord,
However, in the facts and circumstances case, more particular that it was a case of free fight.
free fight.
Considering the fact that weapon used by the accused Ramavatar Farsa and he
Hmm.
caused the injury on the vital part of the body, that is head,
Head,
which
my-
proved to be fatal. In the
Yes.
facts and circumstances, we are of the opinion that High Court has committed in grave error in altering the conviction of accused Ramavatar
Yes.
from section 302
Yes.
to section 304 part 2.
It was my lord. So, High Court said this, my lord, the conviction of accused Ram Avatar is altered 302 to 304 part 1 and 4 is granted to time. Free fight, no, civilianism. So, man, again, part 1, conviction part 1, my lord. And here also, my lord, another thing is that from the judgment, my lord, it is the blunt part has been used in my lord assaulting, my lord. That has all, even though it is a blunt part, my lord, it is made under 304 part 1. The last part, my lord, lordship will find in the paragraph 3. May I read one thing?
Just a minute.
Yes.
Let us see 304 first.
Lordship.
IPC. IPC. What do you want to show me?
In that, my lord, that regarding in a judgment, my lord, second page, paragraph 3, my lord,
Okay, just a minute.
in the judgment part, my lord.
He has been granted 10 years under
Okay.
part 1.
Part 1, man. Page 304 section, your lordship is.
No, no, that's all. You wanted to show the judgment.
Yes, my lord, judgment, my lord, that paragraph 3, my lord, it is it. As,
Page paper book.
no, my lord, my lord, judgment, no, the judgment I have.
That is
cited.
judgment. Okay,
Yes.
paragraph 3.
Yes, paragraph. Paragraph 3, last part, as held by this court in Katina of decisions, even in a case of single blow, but on the vital part of the body, the case may fall under section 302
Two.
IPC, my lord.
That I have read.
And the accused can be held guilty of 302 IPC. my lord. But here in this case, my lord, the lordship may kindly come to the, my lord, postmortem part, my lord. Once again, if the lordship comes. Evidence of the doctor, my lord.
Hmm.
Then it will find.
That is
That is, my
which
lord,
page?
it is.
33.
Yes, my lord.
I think page 33.
Yes, ma'am. PM. It was page 34, my lord.
Hmm.
Injuries, my lord. On stitches own opposed by black silk 5 in numbers over occipital region on midline. On removal of the stitches, the margins were found contused. Adjacent areas of the scalp is contused, covering an area of 4 into 2.5 centimeter over occipital region. The skull underneath the seat found fractured, depressed, and communicated. That is injury number 1, my lord. Now comes the injury number 2. Contusion of size 15 into 10 over right temporal parietal region 4 centimeter, right from midline centimeter above the right eye, right ear, my lord. It is in this portion, my lord. Right. And underneath the skull found fractured, depressed, communicated. 2 fatal blow in the head, my lord.
Yes.
And in Ross also, my lord. Lordship may kindly come page 35, my lord. First paragraph, my lord, he has specifically, my lord, stated in the cross part. I have found injuries on the head only in 2 places.
So, my lord, my submission in this regard is that, my lord, it is that there is, my lord, 304 part 1 is rightly convicted, my lord, because so far as, my lord, injuries are concerned and with the intention, my lord. Even in the case of single blow, my lord, that is.
No, that is,
yeah.
there is no problem
And
on
so,
that.
my lord, now the case is that he was subjected, my lord, 2 blows in the very vital part of the, my lord, the head, my lord. That is why, my lord, the learned apex court has stated, my lord, the vital part when the injury is caused, my lord. And that is in a single blow, my lord. It can be a whole under 302. Now it is, my lord, 2 injuries in the same region, my lord.
The distinction is the intention.
Intention. Likely,
Whether
whether likely
Likelihood
or
that whether
a very
one
thin,
part is that
very thin distinction, my lord.
very strong distinction.
Very, very thin, my lord. And that is why I'm, my lord, stressing that. my lord.
When if the act by which the death is caused is done with the intention of causing death or of causing such bodily
as is
injury
likely to cause death.
likely to cause
Cause-
death.
Yes,
So your argument is that the injury is such, not a single, here than that second,
Mm.
and therefore he is well aware
yes,
that even he might not have intention,
Right.
but he know that it is likely to cause death.
likely to cause
So
death,
it is part one,
part 1, my lord.
okay?
Mm.
And Mr. Sheikh's case is that
Now, part
there
2
is a
is
free
the-
fight.
but without, second part, is but without intention to cause death. That is one thing.
According to Mr. Sheikh, yes, there was fight, no doubt about it.
He has the knowledge, but no intention, my lord. In part 2, my lord.
And there is no intention to cause death
Without part 2,
or to cause such bodily injury as is likely to cause this.
yes, likely to cause death.
Cause death.
And also, my lord, may kindly see, my lord.
So here your argument would be when there is two injuries in the vital part of the body,
So intention,
general normal human being will know that it is likely to cause.
likely to cause death and also the intention to cause death.
Okay.
Second part is that, my lord, which may extend to 10 years or both.
Mm.
If the act is done with the knowledge, first is the knowledge, my lord,
Mm.
that it is likely to cause death,
Mm.
but without intention to cause death. So in part 2, my lord, it is stated that without intention to cause death. So
Okay.
if had it been a single blow, without considering the, my lord, apex court, without going to the judgment, then we can say, yes, in a spur of the moment, he made a single blow. But, my lord, 2 blows and 2 fractures, my lord. So now the case is absolutely clear regarding 304.1.
Yes, that's all.
Yes.
Yes, Sheikh, anything to reply?
My lord, my first submission before your lordship regarding two blow, my lord.
Mm.
My learned friend
Mm.
kindly try to
Mm.
bring my case under 302 or 304 part 1, that there should not be shifting. So, my lord, to that my humble submission before your lordship, the doctor says that 2 injury was found in the head part. So my humble submission before your lordship, from the entire evidence on record,
It's a single hit.
nobody said that he was repeatedly hit, but your lordship will consider occipital region, a blow has been made by hard substance. So that injury may be in other part also because it is broken. So my humble submission before your lordship, it is not the two blow. If it is two blow, it is difficult to go to 304 part 2, 1 part 1.
Even if it is a two blow,
Hmm.
there may be, since all the witnesses says this is the single blow by
Single.
this person, this may be from some other also.
Dubar maar
Because
se-
most of
Two
the
times-
witnesses say that so and so also beated so and so, so and so. So that hit
But-
may be from other part, any other accusers,
But
which
when
is not
Yes.
identical. That
But
will be your argument.
Yes, but the head injury is, my lord, very specific, that he is assaulted on the head.
Head. Yes,
That is
assaulted.
No, that is there. There
Yeah.
is no problem with that. But thing is this, my lord, what my learned friend tried to bring so that I cannot get benefit of 304
Part two.
part 1,
Hmm.
like this. But my humble
His case
submission
is
it
that
was
in
one
fact,
blow.
in fact, this was a case of 302. However, taking a linear V, it has taken as a part one.
Amount not
Even, my lord,
inside.
ignoring that two blows are there, my lord. Then also, my lord,
My lord,
the
two
honorable court has
My
specifically
humble
said.
submission before your lordship, from the evidence on record, two blows is
Understand,
not.
your case is that so far relating to the appellant, all the witnesses, this is the single blow.
Yes,
And it is also established that it's a pre-fight. So the second injury cannot be attributed to the present appellant. This will be
yes,
your
ma'am.
case.
Yes. Another thing is, your lordship, I want to draw your lordship's one thing. I have stated before your lordship that exactly a Mokbul, brother of Dulal, attempted the assault and to Arozali, and assault fall on Dulal. That was initially I have said. Now your lordship would be pleased to,
But Mr. Sheikh,
my lord.
see, giving a defense witness, there must be some foundation.
Hello.
Isn't it?
No.
Without any foundation, during the examination in the prosecution witness, your whole case is that there was a land dispute
Yes.
and there was some fight. Okay, that is fine. But it is not a case that this blow was given by somebody else. This was not there. So let us not waste time on that.
Also, my lord, that
Only,
there are only
only I want to
Of
point
course,
out.
of
before
course,
your
there is,
lordship,
you have not created any dispute as regards the incident on that day. As regards dispute over the land, there is nothing. Or to a extent, you have suggested that they are the aggressors. These are fine. But the story of falling it, using somebody, falling it someone, this is not at all defense case all throughout this prosecution.
my lord, I only want to bring one point, my lord.
Yes.
That is Dulal's wife, my lord,
Hmm.
Hamida Khatun,
What she says?
accompanied another eyewitness, my lord, Rabia, to the place of occurrence. But unfortunately, my lord, or fortunately, that Hamida Khatun withheld by prosecution. That creates another doubt. Because, my lord, Hamida Khatun related to Somed, they are related each other, and Hamida Khatun was withheld. Hamida Khatun being the main sufferer, Dulal died. Hamida Khatun was also present on the spot as per evidence of PW7, that Hamida along with me went to the place of occurrence. She also eyewitness, but Hamida is withheld. So, my lord, I faintly try to bring this, that this blow by wooden bottom, my lord, may cause some damage to the prosecution witness. That is why she was withheld. Why she was withheld? That is to be explained by the prosecution. She is the eyewitness and vital witness. So, my lord, another thing is this, as there is no injury, two injury was not, so there was no intention. It is a spark of the moment, something as that. That's all. That's
Yes,
all.
I have two things I would like to make clear, my lord.
Hmm.
Regarding, my lord, why she is not examined, my lord, there are certain catena of decisions, my lord. It is, my lord, only not the quantity of the witness, it is the quality of the
Yes,
witness
yes,
which made, that is one part. And secondly, my lord, a learned friend has said that only single blow.
That sometimes withdrawal of witness may lead to adverse consequences when there is no other material,
Other material.
or there is a vital link of that
Link.
witness.
Yes, my lord. That part, my lord.
Suppose you say that so and so was present,
Hmm.
and others say so and so
Yes.
present, and he first witnessed the
Yes.
thing. He was withdrawn. Then what
Yes.
was the explanation? Why
Yeah,
withdrawn? Here, not only see, there are many
Many
persons who were
persons
present. The
present.
injured witness are
Also,
examined.
yes.
So
Yes.
here it will
Yes,
not.
and one thing, my lord, regarding the, my lord,
But
that
still we
same-
are thinking about the second part.
Yes, my lordship is discussion, my lord.
No, no, not discretion.
My lord-
See,
my-
we want everybody's assistance.
Lordship,
We cannot do things discretionary.
lord-
Let us start the dictation.
yes, yes, my, that one point I would like to clear, my lord. My learned senior offender said, my lord, he was given one blow. My lord, nowhere in the, my lord, evidence it is stated that only one blow, my lord. It is stated that he was hit in the head. He was hit in the head. So he was hit in the head, not he was one blow was given by, that is not the, my lord, evidence. It is stated that, my lord,
Okay,
subsidiary
Let us
caused hurt
start
to
the
the
dictation first.
lordship.
Then we'll record your arguments also so that then final part we may keep it. We do not know.
Lordship.
Heard, Mr. Sheikh.
My lord, regarding the Supreme Court judgment, my lord, I have not gone through.
Yes,
It
my
is given to your lordship.
Here's
Only thing I want to
Sir.
point out with your lordship.
Hmm.
that It is a settled law, my lord, that every case is to be considered
on his own fact.
a own fact. So, my lord, that Supreme Court decision, what
Hmm.
my learned friend pointed out, my lord,
What
regarding.
we really, what will guide us is the ratio, not the facts.
My lord,
Anyway,
your lordship, what my learned friend placed this Supreme Court judgment only to make this point, my lord. Occipital is done, heat was made, but under what circumstances? What was the facts of the case?
heard Mr. Sheikh,
Otherwise-
learned counsel for the appellant. Also heard Mr. MP Goswami, learned additional public prosecutor Assam, appearing for the state respondent. Anybody from the private, any notice? No, na? By the impugned judgment and sentence dated, just help us.
My lord, shall I give it?
Which one?
Date of the judgment.
Just tell us.
My lord,
Tell us, we'll go and just.
The injured witnesses. that
No,
is-
judgment, impugned judgment and sentence dated
date.
of the judgment.
My lord, I'm giving.
Just open your appeal memo.
My lord, just 1 minute.
Yes,
Yeah.
regarding the.
I can open, but
Yes.
I'm sitting in a relaxed position to dictate.
My lord,
14, 4, 3 and 7, they are injured witnesses.
13-9, my lord, 13-9-2020.
13/9/2020,
Yes.
passed by the learned session judge or additional session judge.
Morigaon,
Session judge Morigaon, in session case number
36/2013.
36/2013. The present appellant is convicted under section 304, part
Part 1, sorry.
Part 1 IPC and was sentenced to undergo rigorous imprisonment of life. Rigorous imprisonment
10 years.
for 10 years
Fine
and
of
Swenso Sailava.
And fine of rupees
Fine of rupees
20,000.
20,000. Full stop. By the same judgment, how many other accused?
Eight, how many, my lord?
How
Eight-
many,
8 persons were convicted.
Ah.
For fine of
including
ru-
this 8 or including this, excluding this 8?
no, total 24. Total 24 accused.
Ah.
8 were convicted.
8 were convicted, 1 is this person,
Yes.
and other 7 or other 8,
No, my lord,
total 8.
that eight is convicted in excluding Somet, my lord.
Okay, full stop gulo. Other 8 accused were also convicted under section.
My lord, just 1 minute, my lord, I am giving.
We do not think do you expect anything to be heard today?
Regarding my,
Any other method?
no, cannot, my lord, because the case is 31 is there, my lord. No.
Definitely will left. Why you are sitting? He is an experienced senior counsel. He should know when, and the second half or hearing is started. And court expressed that we will dictate the order in the open court. Expectation should be to a limit, isn't it?
So there's a lawyer from Delhi who will come, so the date, consensus date was 9th of,
Yeah, that is no problem. They will give, will
and
pass.
the interim order needs to be extended.
Okay.
Under section 334.
Let us not punish others for our job. Yes. What is your case? What happened to that?
I think that may be.
And Ahmed was there. Where is he?
Lordship, he is also in this case, Lordship.
Okay.
Next week, Lordship.
Give a consensus that we do not know. Next. Convicted under section
334 IPC
334 IPC.
and
Full
given
stop.
fine of rupees, imposed fine of rupees 500.
And fine of rupees
500 is
500 each were imposed. Full stop.
14 accused were found not guilty.
Full stop. 14 accused who were tried were acquitted by the learned trial court.
From the charges under section
From the charges under
147,
147,
148,
148,
102B,
102B,
341,
341,
323,
323,
325,
325,
302 IPC.
302 IPC.
And one person, Mormuz Ali,
One accused, namely
Mormuz Ali,
Mormuz Ali,
died during the
expired during the trial. Full stop. The prosecution case in brief is that on 30/12/2011, one Muhammad Mujibur Rahman lodged an Ezahar with the officer in charge Lahorighat police station, alleging inter alia that on the fateful day, that is on 30/12/2011, at about 8 AM, 19 persons, FIR name 19 accused persons, in pursuance of a criminal conspiracy, armed with dao, spear, lathi, etc., came to the informant's land on a dispute as regards a road and assaulted the father of the informant, namely Samsuddin, with sharp object causing grievous injuries on his person. On knowing about such incident, knowing about this incident, the other brothers of the informant, namely Saiful Islam, Mokbul, Nazrul, Khazul Islam, Dulal, within bracket deceased, Uncle Abdul Hakim, nephew Ikramul Hussain, and cousin Nurul Amin went to the place of occurrence. And then the accused person assaulted them with sharp weapons and caused grievous injuries to them. It was further alleged that the accused person snatched away a gold chain from the neck of, okay, not necessary, forget about it. Full stop. On receipt of the FIR, Lahorighat PS case number 181/2011 under section 147/148 section 120B /326/325/379 IPC was registered and investigation was started. Subsequently, the brother of the informant, namely Dulaluddin, expired when? Expired on
My lord, I am giving.
expired on this
Parents. Mhm.
during
Mm.
while he was under treatment
Yes, one.
for the injuries sustained in the incident. Accordingly, section 302 was added. Full stop.
1 day later he died.
Hmm. We'll just find it out
Yes,
later.
1 day later he died.
Full stop. Hello?
Apply for fellow.
On completion of investigation, the investigating officer had submitted search sheet against 19 number of accused, including the present appellant. Present appellants. On the basis of the search sheet, the learned session judge had framed charges under section. Where is the charge? Heading of search silaba. Huh?
8 to 10 months.
Search, section 120B, section 120B/341/323/325 where is 302?
My lord, page 9 at the bottom, my lord.
Bottom 302. Section 302.
Like this.
Full stop. 302. Since the appellant had pleaded not guilty, the matter went up for trial. During the trial, the prosecution had examined as many as
15 men,
15
15 witnesses.
15 witnesses,
My lord, 16
witnesses.
16 witnesses, including Dr. Ayo.
16 witnesses to bring home the charges framed against the accused. In their statement recorded under section 313 CRPC, the accused had denied all the incriminating circumstances put to them. The defense also examined as many as
Four, my lord.
4 witnesses.
Date is 1/1/2012.
1/1/2012, date of death. He subsequently died during treatment on
He was admitted on polyclinic on 31/12. As per next day he died.
14/1.
Yes, ma'am. 31/12/2011 admitted. And next day, 1/1 that will be 2012.
1/1/2012. Full stop. The learned trial court below, after considerations on material available on record, concluded the following. Just shortly, concluded following, that the case is of free fight between both the sides on the right of use of a part as the part was claimed by both the sides. Full stop. Prima facie, the accused side has the possession over the disputed plot of land. Apparently, it appears that the informant sides were the aggressors to infringe the right of possession. Next, though the accused side had the right of private defense to save their property, but apparently the accused side had taken the law in their hands, knowing fully well that a proceeding is pending before the district magistrate Morigaon as regards the dispute, as regards the dispute, civil dispute. Full stop. The accused side had exceeded their right. Full stop. Next. The appellant, accused one, had physically assaulted the deceased Dulaluddin on his vital part, that is on his head. Such assault is covered under exception 2 and 4. And therefore, though the prosecution has been able to prove the case against the accused appellant Samed Ali for commission and offense under section 304 part 1, but failed to prove beyond reasonable doubt as regards commission and offense under section 30 under 302 IPC. Full stop. 30 IPC. Accordingly, the accused was convicted under section 30 part 1 as inasmuch as the accused had knowledge and intention. Knowledge and intention. That is the findings of that.
Part 1.
Part 1. Knowledge and intention. Full stop. Mr. Sheikh, learned counsel for the petitioner, argues the following. 1. The prosecution had miserably failed even to bring home the charges under section 304 part 1, in as much as it was a free fight. It was a free fight and there was a serious doubt who actually inflicted the injury upon the deceased. Full stop. Alternatively, yes, Mr. Sharma, at 3:30. Huh?
With due respect of your lordship, with
Yes, you
permission,
are here. That's enough. Yes, tell us.
I wanted to mention
Hmm.
for tomorrow and anticipatory bail application. If your lordship is permitted,
You make a mention tomorrow unlisted.
tomorrow.
Because what I'm saying is after 12, if you mention also, it cannot be listed.
Supplementary may be listed.
No, because it mentioned and this memo is to go to the registry before 12.
No.
So therefore, make a mention unlisted tomorrow. If it is above 7 years, then here.
That is my. Okay.
If it is its bench, its method can be taken up by this bench, make a mention. We are allowing all mentions. No problem on that.
Master, please.
Yes.
Thank you.
করেছিল?
Yes. Right, and there was this who actually put the injury upon the disease.
Hmm.
Alternatively,
And therefore, such benefit of doubt should be granted to the petitioner in as much as without their having any cogent material, only the present appellant is convicted under under section 304 part 1, and all other accused person who were also part of this fighting group has only been convicted under section under section 340. Others
34.
full stop. What was your second limb of argument? Mr. Sheikh further argues that even a serious doubt has been created as regard the weapon used in the commission of the offense. The alleged eyewitness, some of the alleged eyewitnesses had deposed the weapon by which the injury was inflicted to be what you call kukri? What?
Khunti.
Khonti.
Khunti na khunti.
Khunti. Khunti. Khunti. Inverted comma. And someone deposed it to be Siprang. And one witness even deposed that it was a wooden bit or something like that.
Then Batam.
Wooden, it's an wood.
Pitch of wood.
Batam. Therefore, in view of such doubt, the petitioner, the appellant, is entitled for acquittal. More particularly, in a situation where admittedly the fight was a free fight involving the two groups consisting of 35 persons. Full stop. Alternatively, Mr. Sheikh argues that even if it is held that petitioner appellant was involved in the commission of the offense or had actually inflicted the injury upon the deceased, then also the case on the given facts in the given facts can at best be offense under section 304 part 2. Inasmuch as there are sufficient material on record that there is no intention of the accused to cause death to the deceased, inasmuch as deceased. Further, it is established by prosecution themselves that the deceased were the aggressors. Also, accordingly, the petition appellant is entitled for lesser punishment. Per contra, Mr. Mr. Goswami, Learned Counsel, submits the following. One, the eyewitnesses examined, the testimony of the eyewitnesses examined remain firm all throughout. And their testimony that it is the accused appellant who inflicted the fatal blow with a blunt weapon, that is, with a blunt weapon, has been established. কি বা কেনেকৈ আৰম্ভ কৰিছিল বাক্যটো? Established, full stop. In fact, during the cross-examination, they have reaffirmed such stand. Therefore, the prosecution has been able to prove beyond any reasonable doubt that it is the accused appellant who inflicted the fatal blow on the head of the deceased. Full stop. Mr. Goswami further contends that such testimony of the eyewitness has also been corroborated by the doctors who first examined the injured as well as the deceased, and the doctor who conducted the post-mortem report. The injury report exhibited remain unchallenged. Therefore, unchallenged, full stop. Accordingly, the learned trial court has rightly determined the issue. Rightly passed the judgment. So far, relating to the এই ওপৰত তাতে এটা কবাত লিখি থোৱা দেই এই য'ত হেৰি কথা কলো শেখৰ কথা যে কলো য'ত কলো যে there is a doubt as regards the weapon used in the commission of the offense. Mr. Sheikh further contends that the investigating authority even did not seize the weapon used, alleged weapon used in the commission of the offense, which is fatal to the prosecution case. Okay? Full stop. As regards the alternative argument of Mr. Sheikh, Mr. MP Goswami, learned additional public prosecutor, submits that when it is established that the fatal blow was caused by the accused appellant, and when it is established that injury, the deceased sustained injury on his head, which was caused by the accused appellant, and when such injury is established to be in the vital part of the body, that is head, merely because this court, the learned trial court has rightly convicted the petitioner under Article 3, section. When you read code, judge comes to this,
Yes.
there is, he'll say section is article, section 304, part 2, IPC. He further submits that, in fact, the learned sessions
Part one.
court was lenient, was lenient and convicted the petitioner under section 304, part 2, and not under section 302, IPC.
Convicted and 304 part 1.
Part 1, sorry, part 1. Sorry. He further contends that free fight cannot be a ground to not to disbelieve the eyewitnesses, inasmuch as except the deceased, nobody were infected, with grievous injury. Then what you wanted to say? So far relating to non-seizure of the weapon used in the commission of the offense, as well as the doubt as regards the actual weapon used, Mr. Goswami, learned counsel, submits that when eyewitnesses' testimonies had remained unshaken, non-seizure of the weapon used in the commission on offense shall not be fatal. Full stop. He further contends that though one witness used the word that wood bottom was used as an weapon, however, the other accusers clarified that the khanti slash, what you call it, siprang, was having a wooden handle. Therefore, such minor discrepancy in the backdrop of unshaken evidence / testimony of the injured eyewitnesses is not fatal to the prosecution case. Full stop. I have given anxious considerations to the argument advanced by the learned counsel for the parties. Hearing concluded, judgment reserved. Tired.
Judgment relied upon.
Okay, Mr. Goswami, in support of his contention, relies on the judgment of the Honorable Apex Court in
2019 6 SCC
2019 6 SCC
809.
809. Per contra upor heri dibo ki naam amar Check box.
I submitted that facts is to be considered.
check dibo. Shekhar.cobo. Okay. Relies on the judgment of Harshan Singh and another versus State of Haryana reported in 1974 3 SCC 393. Sheikh relies on that judgment. Okay.
Lord, the remaining portion of the judgment is reserved.
Yes, CAV.
My lord, one thing I want to point out, I have filed a bail petition. So as your lordship is disposing the appeal, so bail petition IA number 386 of 24 will be closed.
We'll deliver next week first part. Yes, but
There was on item 32 and 33. Your lordship was pleased to take it. Your lordship remember that NDPS case 1.10. So if your lordship has had it on length on the, at least item 32, your lordship can fix it on the availability day, your lordship. Whenever your lordship is present.
Okay. Okay, that was part heard, no?
Yes. Not part heard, but it was hard and length. The order sheet is also reflecting it is hard and length. And lordship was pleased to fix it, two accused, co-accused, or the co-accused. Item 33 is of the co-accused, lordship.
Okay, I'll look into this and I'll do something.
I'm deeply obliged, lordship.
But what to do? Time, at least one matter is hard.
That is understood.
If you take hearing, one hearing criminal,
Yes,
you'll have to
because
give a right of
without-
audience to everybody.
Yes,
This is a last court almost. These people
Yes,
cannot go upstairs.
Absolutely.
Yes,
We'll have to give
Absolutely.
yes.
Absolutely.
Anyway, we can try only.
His luck is bad.
Huh?
This person, my lord,
Mm,
others are all acquitted, my lord.
mm.
Just, my lord.
But he has done it, but
Done it, madam.
let us see how to.
That is why, my
We'll
lord, and specifically, my lord, that is why the Supreme Court has said, my lord,
Mm.
very specific.
This, my petitioner is also languishing in jail for 689 days, lordship.
What to do? We are trying our level best.
That is true. Can understand.
According to me, there should be a special criminal bench for
For-
only for taking appeal.
Yes, yes,
Those who are in jail,
Jail,
yes.
lordship, absolutely, lordship.
those who are in jail. Okay, somebody you have granted bail and all, they are out. Okay, let do. Because those who are inside, they are having an anxiety whether I'll be, if they are in inside, let them be inside. Let there be a decision.
Yes, yes.
Problem is that we are not being able to decide cases. See the 2005 case.
Yes.
We have to adjourn it.
Adjourn it,
What to do?
because he was.
We will have to
time,
accommodate
otherwise-
everyone. Yes, এখানে চেম্বার দিবা। একটু বেলেগ একটু রাখি থৈ দিম। Okay. Thus at least we have recorded therefore
Yes,
so that
yes,
we can
yes.
later on dictate this.
Obliged.
কহিয়া নাহিলেচোন। বনাই দিছো। তালিকাতে সেই বেলেগ
আইপিসি খন ক'বাত গ'ল জানানে এটা দুখন আছিলে মধ্যপ্ৰদেশ
Yes.
মধ্যপ্ৰদেশ
Oh, Mridu Pawan Goswami.
Yes.
Joint registrar, judicial.
বুলি ক'লে আজিকালি ল'ৰা ছোৱালী জানাই নহয়। কাৰণে মানে ক'ৰবাত চবেই যায় দেচোন, লগৰ ছোৱালী মিট কৰে কিবা কৰে, মইতো একো
জানো বন্ধ কৰিছো দেখোন।